Christian. Okay.
Yeah, I'm a yeah, right.
Christian Floyd.
Yeah, I used to be a Christian.
Okay, I got you.
Okay.
So how long you been stuck there?
About 3 or 4 weeks now.
Okay, cool, man. Me too.
You been on about that long too, Gil?
Yeah, about that long, yeah.
Yeah. I think I've heard you before making comments and so on, and sounded like you pretty much knew quite a little bit about this already.
No, just got down on it, man. Started studying. That's all.
Yeah.
I mean, it makes pretty good sense. So it's pretty logical.
Yeah. Yeah. I was listening to Christian's program from last night. He had it on. He had it up already, and I didn't get a chance. Yeah. And I noticed that he went all the way back to. He said that trust actually went all the way back to Babylon. And I was wondering how much they affected us in the United States in that respect, because we've been brought into it back as the 1200s with England. And I was just wondering, I sent Christian some information on that, and I was wondering just how that those trusts that were created back then affect us now, because they're supposed to be carrying on in perpetuity.
Oh, that's a good question. I don't know. I don't know. I'm not exactly sure. From my understanding, in England, they started using trust around the 12th century, and I think they got them when they went to the Crusades.
Yeah. Well, I can get that. Bring up the information for you.
Okay.
I sent Christian, and just to make you aware of it here. Let me see.
Okay, I'd love to.
Christian here.
Good evening, Christian. Bill here from New Jersey. How are you?
Okay, good. You?
Outstanding.
Floyd from Virginia here, Christian.
Hi, Floyd.
Hi. I just sent you an email on some things that brought the United States into subject to England over since the about the 1200s, and I don't expect that you've seen it yet, only because I just sent it just a little bit ago. But I was listening to what you were saying last night on the on your program, and you were talking about trust all the way back to Babylon.
Right. Yeah.
And I was just wondering, I was just talking to Bill about that, and I was just wondering how much that's affected us throughout history up until now in the Constitution.
Well, it even goes back farther. Yeah, it goes back to the Garden of Eden, so in Eve's time. Let's go back.
Are you still there?
Yes, I'm here. Mm-hmm.
Oh, okay. I thought we got cut off there for a second. Well, one of the things I was talking about is the Carta that was formed in 1215, the Magna Carta, and the king. It says the king started businesses or trusts called Virginia and Carolina in America, and these American charters were non-revocable trusts.
Yeah, I think the king trust in the history of America was in Massachusetts or some land corporation. I forget the name of it. That was the first recorded trust in America. I guess it's still.
Who formed that trust?
I believe the people of Massachusetts formed the Massachusetts Land Trust.
Mm-hmm.
Still in existence today.
Okay. Well, according to that information that I sent you, you can look it over and see if how much you agree with factual. Anyway, I don't know. I haven't checked it out myself, but it's supposed to involve the allodial ownership plan. Yeah. And it says. Where the charter, the king retained for himself and all his heirs and successors 30% of all gold, silver, and copper to be sent to him annually.
Mm-hmm.
Our forefathers.
That was out of the Magna Carta, you said? Or?
Yeah, that was out of the Magna Carta.
But that was the Virginia Compact that they signed with the Virginia people. That was part of the condition of that agreement.
Yeah, it was Virginia and Virginia and Carolina.
Yeah. It's not usually expressed as written as a trust. They just say there was a covenant or an agreement between the king. That was his share for granting those people the right to explore the land for him.
Mm-hmm.
And in Virginia, unfortunately, there was no gold or silver, basically. So he sort of like missed out on that one there. And I think that trust was revoked for some reason, and he just took over anyway. The king did.
Yeah, it was revoked by the Pope, is what it says here. He declared the Pope.
Let's move forward a little bit. Let's go to 1776 Declaration of Independence that we fought a war with, and we made a declaration or formed a new trust that we are totally free, and it was really by gift of God, with no allegiance, no responsibility, not responsibility, but no obligations to anybody else, because everybody else was cut off because of the war. And the only thing that was holding us back was the commercial debt.
Yeah, isn't that what brought us back under the king? Was because he set up a trust or something to when the founding fathers
from France, the King of England.
Oh, that was the King of England. Oh.
Yeah, King of England purchased the debt of France because we owed France the debt with the war debt, and the King of England purchased that war debt. So now we're under full obligation, and that's the only thing that's holding us, because technically this country fought a war that freed us.
Mm-hmm.
The Declaration of Independence that declared to the world that we were free, and nobody said otherwise. So now it's standing under international law that this country is free. But the only thing that's holding us back is that debt, that original war debt. That's supposed to be traded and exonerated for trading for shares of stock in the United States Corporation.
Okay, that was the corporation that the king founding fathers set up, was my understanding. Is that correct?
Yeah, I believe that could be, the whole implementation to get us back under the thumb.
Yeah, I think the idea was that he didn't want to bring the people into the agreement. He wanted the corporation. He wanted to make the agreement with the corporation. I don't know what his thinking on that was.
It still is with the corporation.
Pardon me?
The agreement still is with the corporation.
Yes, it is. Actually, it is.
Now the question is, every time somebody gets corporate, then the real live man shows up.
Right, exactly.
When he really didn't have to, because he's not the corporation.
Yeah, that's true.
So he's surety under a debt of creditor, but here was a trust all along. He's expressed it to being a trust at the show. because you should have been as a real live man, but yet it was original complaint, that corporation, where it had to be, to summon in, or to subpoena in the real live man, it had to be a subpoena.
Mm-hmm. Okay, so the subpoena is what affects the flesh and blood man, and the summons is for a corporation.
Yes, and every time they get an action, what do you get first?
So they always get a summons.
Yeah. Yeah, so who are they summoning in? They're not summoning in the real live man because they can't. There has to be a subpoena.
Right, yeah. They always have to interact through a transmitting utility, correct.
So if you show up as a real live man and you're supposedly a fiction in there because you're acting as the corporation now.
Mm-hmm. Yeah. Well, that's one of the things that...
You don't go in because you're not the corporation. Well, they'll continue on the action of the corporation and foreclose on the corporation. And since the colorable titles are held as colorable titles to the incorporation there, they're going to seize the property through the colorable action through the corporation.
Mm-hmm. Yeah, okay, right. Yeah, so as long as you say so long as you take the place of the corporation, then of course they're going to agree with you.
Right, so I got to go into court, put on the face mask of that corporation or that straw man, act as that entity, that fictitious entity, present a non-colorable or a colorable action in there that they can do a little bit of manipulating around so I can get in my hearing in chambers, so I can bring in the real truth that I am the real man and I'm not that corporation. And that would be through in chambers.
Yeah.
Stress that in the trust, and then merge the title, that trust as payment for a special deposit.
So you're actually at that moment, then you are going in answering as the corporation then?
Yeah, you almost have to, because otherwise they're going to still take your property. You gave them the property under trust. It's there. You're there sitting there holding it. You gave it. You gifted it to them in trust.
Uh-huh.
Now you have to get trust.
Okay, so that's when you accept that. That's then when you accept the document as grantor. Then.
Yeah, I'm accepting that summons as the grantor, and then going to come into chambers and prove that I am grantor
and beneficiary. Yeah.
Mm-hmm.
Okay. Yeah, I was listening to your program from last night, and that's when I was beginning to wonder, just how much the previous actions of England had in making it free had affected us. So yeah, so you brought that. So you pretty much cleared that up then.
Okay.
Well, that's good. Because I was wondering how if we were still under some kind of a trust with England, and it had to do with money, how the collapsing the public side of the trust was going to, or fulfilling it was going to help us.
I agree with you that we are under some kind of obligation.
I'm going to try it.
We're now recording, so welcome everybody to this March 2nd, 2010 show for Money Banking and Trust. I'm your host, Christian Walters, and we're in a Q&A mode for questions and answers, so let's continue on where we were there.
Okay, so where we were is establishing the fact that the trust is, we've already discussed previous to this, that the trust is what's taking the place of the fact of real money. And that's what has brought us into trust, is I think what you said before, right, Christian?
Yeah, the real money's still there, held in trust, waiting for the trustee to wake up and do his job.
Oh, okay. So So then, when we merge the titles on the public and the private trust, that's then when the money is going to be released or fulfilled, however you say it, the trust.
Yeah. But I think what they've really done is they've gotten rid of the money that was held in trust, and they probably were going to blame it on us. But if we terminate that trust, we should get those funds back, what was deposited in there. And since I don't think they're going to agree to that, they're going to try and give you certificates of gold or certificates of something, which is nothing more than fiction titles again. And if you put gold in, you need to get gold back out, your special deposit. And I don't think they've got the gold. What they're holding is IOUs, because they got rid of the gold to, say, China or wherever, Germany. And they've accepted IOUs in exchange for that. So then if we take, I'll take the IOUs and then tell them to put that back into trust. It's going to be my trust now that I know about. And I'll hold that on the private side. And then I can do the public interest drawn against that private side deposit, that new trust. And then that interest, I'd live on that for the rest of my life. And nobody would be any wiser, because that's generated on the public side, and that's going to be converted from credit into Federal Reserve notes and whatever. It's going to look just like everything else. I'll be able to write checks. I don't see any problems.
So the fact that they're not giving us what was put back in there is not going to nullify the action that we're taking, then, right?
Well, we still have an obligation that's owed back to us if we made a special deposit. You could make a case for a breach of trust or an antitrust case and get them for commingling the funds because they can't give the original deposit back. Well, I would just give them of that debt, that obligation, and say, okay, let's form a new trust. Put your certificates in that is mine. Put that in that new trust in the Treasury. You guys take care of it the way you were, but this is all under me now.
Okay, I see.
My trust I set up that I'm aware of.
Otherwise, if you want me to sue you for commingling funds, then we can go ahead and do that then too.
Yeah, I want you to generate the interest on the public side that looks just like everything else. That way, nobody's the wiser, and we'll just go from here, and we'll just now conduct business differently, because I'm not going to do commerce any longer under debt. Okay. The interest going to be generated is going to be not effectively connected with a trade or business in the United States. Now I'm a non-resident alien, and I don't fit into that realm. Question?
I didn't have a question.
Everybody's speaking. Would you press star 5 and mute out?
Can you hear me?
Yes.
Can you hear me?
Who's that?
Hello?
Yes. State your name, where you're from.
Hey, Christian, this is Karen.
How are you?
Good. Hey, had a question. I was wondering in regards to this previous case, which I bonded via private indemnity bond back in 2008, which the Department of the Florida Department of Revenue would not accept it, even though they accepted a previous showing it being. I basically claimed that case on UCC1.
Yeah, I would think so.
Can name the trustees on that same financial statement.
Trustees on the same financial statement. From the original one? Yeah, I would think so.
He had another I claimed bond registered man. Now the thing is, if it was bonded, and there was some overages to that, would that be like should the bond been like a special deposit, which was, well, I would have to send it to you for you to look at it, because I set up like that. I was wondering maybe if that made an error somewhere.
Yeah, well, watch about putting these bonds and stuff in, because we're just more debt, so. Away that stuff, the bonds, because if I go over the indemnity bonds and all the offset bonds, I'm staying away from them from here on in.
Well, the thing was, a friend of mine, one case they accepted, closed the account. The second case, they actually wrote me. Zono was, and I'm going, well, there's no way, because you basically, and they're not doing it for this, and so they're basically trying to be discriminatory, even though under the term exactly butted or refused, and when that happens, because it is accepted once they bond, then it shows that they actually it was a bonded promissory note, and basically under UCC 3-603 under a payment, and also goes under 28 USC 2041, 42, 43, which is deposits of money in pending or adjudicated creditor.
Now, where's the trust stuff?
Well, that's it. I've never created the UCC1 and basically put that in. I can still do that, though, right?
Yeah.
Mm-hmm. And this is my question. So what I can do just basically claim it. See what that
form never was done prior.
Right, because that also, even under UCC, it goes under payment, and also same thing under UCC
under trust
3.
Under UCC, if it's going under trust as a payment, it's because you merged the two titles, which was the offer not for the creation of the debt title, that you turn back to them as special deposit, which was the title for the asset, and the two merged together and cancel each other out.
Right, it goes back to discharge and effect of the discharge, in a sense.
Yeah, but then merging the titles under Section 159 in Gilbert's, which merging of titles is payment.
But here's another thing, and answer this, because I made Bill McClellan, the Florida Attorney General, he was the appointed fiduciary on the field or denied or anything like that. In a way, as a fiduciary, even though it's not specifically claimed in there.
Well, do you have a notary presentment of the bond?
Yes, everything was done, notary presentment, and a certificate of dishonor was issued.
Okay, so you got to create the evidence for the notice to point to that present transfer that happened, say, whenever it happened, say, 2-3 years ago.
Right, yeah, 2008. Okay, so basically I file it into UCC1 then, at this time.
I do a 1 in a county, and then do a 3 in a county. So now you created 4 records for the claiming, for the transfer.
The first thing I do is the state level and at the county level, and then the 3 at the level. Okay, well, pretty much what I want to do. Appreciate that. Thanks much.
Make sure you got the elements, the 4 elements, and you got the method of form. and to prove
Correct. Right, exactly. Speaking to a gentleman down in Florida also, we had a great, and this is something to what you're saying, when you bring everything in chambers. When you bring everything into chambers, in camera in chambers, remember what a judge does when he gets into chambers? He takes his robe off. That means you can speak to him man to man.
Yeah. Now he's a judge.
Right. Now it's man. And now he judge for as a man because he just knows being basically.
Now you're in equity. Equity is trust.
Okay, equity is trust. Okay.
Want to be in equity? You gotta play the game until you get into equity, and then you got the upper hand once you're in equity.
Okay, very good. Okay, good. All right, super. I appreciate that. All right, thanks.
Yes, Christian?
Yeah, go ahead. Who's this?
How you doing?
Good.
Good. I was reading the Practical Treatise on Trust on page 37. Lord Mansfield is talking about the confusion between and I guess lawful courts. And it occurred to me, I don't know if it's right or not, but that's why we have the equitable title. Is that the law part and the equity?
Equitable title is the beneficial title and the beneficiary.
Right, but
The legal title.
Right, but it seems like, are they two different types of law?
Well, you can have in a trust, you can come at some law on the or you can in equity on the private side.
But let's say in the private side.
Forms remedy, you got a equitable remedy.
Oh, okay, right. That's what I was saying. So there are two avenues you can take.
Two remedy avenues you can take: at law and equity.
So one is public and one is private. Is that what you're saying?
Yeah, the at law is on the public side. The equity side is on the private side.
So in the trust upon itself, there are two remedies.
Yes.
Well, that's like that.
Right.
Okay, thanks.
You have a collection coming at them on a tort claim for something, say breach of trust, and then evidence for the private side. Trust.
So that's right. Legal. I never thought about it, so I read this.
Come out with damages on the at law side.
Right. And the equitable side is the side of conscience, the conscious side.
Yeah, that's going to be compelled not to do the breach.
Mm-hmm.
And I keep stressing that that's an important part, that none of us are enforcing our strongest part, which is to force them not to breach the trust before they breach it.
How will we do that?
Well, you know somebody's going to breach the trust, or it looks like breach equity under a and come up.
Well, culpable claim first?
Yes, right.
And you go through your protective orders and all that kind of stuff?
Yes, same thing.
Okay, cool. So what you're saying is we need to be proactive as opposed to reactive.
Yes, and if we were more proactive, we wouldn't be in this mess.
Gotcha.
But we need to take the power that we've got all along. We're wearing the red slippers like Dorothy and the Wizard of Oz all through the movie. All we have to do is just realize we got the power, we got the slippers. We just need to know how to use them. Now, I want you to put your heels together 3 times, right title and interest, or in equity. Back home.
And we're using the at law. Is that
we could take the UCC and just use the words without the numbers, right?
Well, on the at-law side, you can go in and say for statutory and come in with the statutory stuff.
At the UCC, parts of it is trust because it's banking in terms of that nature.
Yeah, it's simple on both the trust.
So that would be under the at-law or in-law?
Yeah, the statute. And you got the other trust. The trust of equity.
And so basically under the equity, it is our I guess we call it indenture or contract that sets the tone of the law.
It's like the public side of the court really has like two sides. It's got under statutory trust has an equitable side, which is a false definition under equity on the public side. It has an at-law side. This definition under the public side is nothing more than redefined prior to 1933, equity's been something more than statutes and codes, and that's all it is. That's what equity is. So they combine summary judgment. They combine equity, common law, and admiralty into one law form on the public side. But your true equity, which is post 1930 or before you, but only in chambers. And that equity is different from your public side equity that's been redefined. That private side equity is the true equity, which is fairness and justice.
And I guess that's why they say in the treaties, it says that the tendency of the courts at the present day keep jurisdictions distinct. That's between the legal and the equitable.
Yes, on the statutory side and the public side, without giving you the wherewithal to come in chambers with the real equity, which was pre-1933.
So that's why you advise us to read the treatises.
Yeah, they get you to stay on the public side, and you don't ever think your side and access your true equity.
Right. Okay. That's good. Thank you.
Question? Okay.
Hi, Chrissy, can you hear me?
Yes, hang on. I'm going to mute everybody out. You might have to re-mute again, so hold on. All right, you have to press *5 to unmute yourself. Can't hear you. Press *5 to unmute and ask a question.
I was thinking that the public side and the private side were what was brought together in the two trusts, or both sides of the trust, and that was when the trust was fulfilled.
Yeah, you have to ask your question again. I pressed *5, muted everybody out, but couldn't hear everybody talking. So I'm going to press *5, mute everybody out again because there was some background noise, and then press *5 and restate your question. Star 5, mute yourself. I don't know if everybody's speaking. Yeah, there we go. Who's this?
Star 6. Coming in.
Well, why is it Star 6 for you guys and Star 5 for me? Okay, well, Star 6 for school.
And the private together, that'd be moving titles together. Titles, right? Okay, those titles, and obviously.
Okay. Explain to a couple ways that you understand.
Well, the are as one way, and then would be just using your degrees to claim the to claim the res, or to and then using the UCC3 to move the title of that res,
right?
And you're using your instruments in the county as witness that res, and so everything they're doing there is public. And then when you're going into chambers with that public information, you're moving and getting a private declaration, or whatever you call it, judgment.
Yeah, okay, I'm bringing public information because I can't bring the public information in chambers in the private. I can bring my actual private information in that has been... I have to leave the notices, say, still in the public. They're still going to be, in the public. I can't cross them over.
Well, okay. How would I look at that then? Because I'm bringing that information with me.
They won't be able to see it. They'll get that information in there, but they won't be able to see it because that's public information.
Yeah. I know that the private man can't see them in public, and vice versa. I realize that.
Now, once I'm in chambers in the private, now I can bring my private documents in and show them my private documents, which would be the actual transfers of the property.
Oh, okay, yeah, all right. Okay, so then what you've done now, by doing that, then you have brought the public and the private together.
Yeah. All right.
Yeah.
The judge is sitting on both sides. He puts a robe on. He's on the public side. Takes a robe off. He's on the private side.
Okay. All right, I see that.
So he's seeing both information.
Okay. So that the titles are merged. All right. Yeah. Okay, I see that now.
Well, he's giving me the recognition of what we've done on both sides.
Yeah, right. Witness to it then.
Yeah. He's giving me an official record to close down both sides.
Yeah. Okay. Yeah. Okay, well, that pretty much answers my question then. I see that.
Another one?
Yeah, Christian, this is Darren again. I just had a question. On the UCC1, you're always coming in. The straw man's always coming in as the debtor, correct?
Well, no, and the straw man can come in as trustee.
Well, let's just say on a court action, because you want to come in on a court action, that's who they always hang is the trustee in any kind of court action.
I can play that defense. I'll come to court as trustee. My legal right not to have made a payment. And now let's go into chambers, and I'll tell you why.
Okay. But let's say that
we get into chambers, I'll present the evidence that this was a trust and prove that there was a trust, but it was a discretionary trust. And per the discretion of the trustee, since the beneficiaries, who you guys are construed as being you guys, you're bankrupt, insolvent, and I can't make a payment to you because as soon as I do, your creditors are going to take your assets, which would be a breach of the trust. So therefore, I can't breach the trust myself as being the trustee, and I have a legal right not to make a payment.
Mm-hmm. But let's say, for example, you have come in as grantor and beneficiary and have denied being the trust. And like on a court case, let's say you name the other party or the judge as trustee. And just like what I wanted to just kind of using that same scenario, but under the debtor, that would be the straw man and you would be the secured party, and then you would name all the specific...
No. Not under trust.
Not under trust?
No.
Then the debtor would be correct. I mean, the debtor would be
the debtor defendant would be more like the defendant would be the trustee. He's the. But I'm not going to be a secured party. You know, that'd be another term I wouldn't use. I'd drop that from my vocabulary under the trust. Under statutory trust, possibly, but under private trust, no.
But in doing the UCC1, because it does ask the debtor and then the secured party, or you just spelling out.
Those UC forms that when we check that block down in there, what is it, block 5 or something like that, where the nomenclature all changes because we're the little block you check like Baylor, Bailey,
right.
That all that secured party stuff, that nomenclature up there, the debtor up there, all that stuff changes. It's no longer that same thing.
So what are you leaving a blank up on the one?
No, I'm like putting in block 7, which the optional block, and making a little block there. I could put in grantor/grantee, say, and then I could check that, and that my nomenclature change to those terms.
Okay. Okay.
On UC filing.
Correct. Right. What would you
on that debtor grantor trustee, say?
Oh, so in other words, you want to change the words. You don't want to use those words. You don't want it your party. You want to use grantor.
I want to use trust.
Okay, but do you change that actually on the typical UCC1 where your first numbered is debtor's exact full name and then 3 is secured party's full name? Now, would you just cross that out? Would you just cross that out, or is it under, or do you just...
I'm going to put in that one block that says optional down below.
Number 7.
I'm looking at the form. 7. 7 is the optional block. Right in there, trustee/grantor, and put a little block there and check that. And then put their nomenclature change.
Okay, now would you still have to fill out 1 and 3, or would just 7 is fine?
Yes, you fill out 1 and 3, yes.
Okay. Okay, that was it. It was just, I wasn't exactly, I knew what you were saying regarding that, but you just want to change, of course, the titles and the entitlements of the titles.
But gear it towards trust, not towards debtor-creditor.
Right. Okay. And of course, can't you just even if you wanted to, besides number 7, even cross that out? Because you can make any kind of alteration on a form. It doesn't prohibit that. So, I mean, there's no disclaimer saying that you can't mark up our form or anything like that. But you could actually do it and put in those terminologies.
Yeah, if you could get away with it, yeah, okay. But they might not say anything if you just put it in 7 and left their thing, unmarked that way.
Okay. And what was that term that you used for number 7? Of course, we're using grantor, trustee, and beneficiary. What was it called again, sir?
Nomenclature change.
Change, okay. Okay, that was my question. Thanks.
Okay, anybody else? State your name, where you're from. Press star 6 to unmute. Anybody else? Question? No other questions?
Yes.
Okay, who's this?
Hi, this is Carlos. Hi,
Carlos, how are you?
Hi, how are you? Quick question. Can you spend 2 minutes on, we're going to go back to a perfect title prior to 1933, right? Once we go through our journey.
Right.
Okay. Can you explain a little bit on that? Can you expand on that?
Which direction you want me to go? I mean, what
I'm trying to say, pertaining to land, to property, to real estate, we're gonna go back to a allodial title on let's say on one of my properties, for instance, right? Or are we gonna have more? It's gonna be easier for us to own our property free and clear, simple, clear, allodial title, or without?
Yeah, because prior to 33 is when you actually really own property. Post 1933, nobody's owned any property.
The question is this: we don't do anything. I was thinking about it.
The thing that's making it not work is really the trust, because if we went from having money
in 1933.
Yes.
Perfect. I was just
well, nobody needs to know or understand they're forming it.
Yeah, I understand that. Yeah, we learned that from you. Okay. Yeah. Okay.
And really, I've had some people say, how can that be? I've used it. If I can another example, one that's absolute proof, and that is if you go into the county and you look at your warranty deed or you look at your deed of trust, it says in there that there was a grantor, and it says that was the person who sold the house to you, and you are the trustee or the grantee. That is proof that there's a trust. You never knew it.
Well, yeah, it's proof because when they refer to you as the grantor.
Yeah.
Yes, I mean, so actually they did it, and they opened our eyes, but we were not looking at it. I mean, we had it in front of us. That's what I'm trying to say.
Yeah, that's the proof that you were the trustee. You never knew that a trust was formed, and that's the proof that you've been the trustee operating the trust. You didn't even know you were the trustee operating the trust.
Right.
So you operate trust on trust, or
we were doing nothing, right? And we had a trust without even knowing it. Now that we had we know better. That we have the right.
Learn how to that's trust. No.
We want to proper the little guy in the right, and let him disperse that which way he lacks.
And make Peter a co-trustee.
I mean, liable.
Yeah.
Okay, got it.
They'll probably claim, well, that's fine if he just claims now he's got a point.
Do you think that once we are treatment ready, like I mean, let's say 6 months from now, we're in top shape when we're talking about how to express the trust, and we know everything about the trust. So I'm way behind. But anyway, I'm just speaking for myself. Do you think that the Dutch, all of them or most of them, are gonna comprehend our language?
Let me think here. The Lewin Practical Treatise on Trust on page, I think it's 17. Let's see, 17, I believe. No, page 19. Says that equitable estates and rights are now noticed and acted upon in all courts, and where there is any conflict between the rules of equity and the rules of common law, the rules of equity are to prevail.
Right.
And so subject to any rules being made in pursuant to the enactment second of Victoria are transferred to the Chancery Division of the High Court of Justice and subject as aforesaid all causes and matters for the action of trust, charitable or private are to be assigned to the same division, and for that purpose every document by which cause or matter for that to whom or matter is assigned. So,
right. And I think someone told me that Judge David, in front of you or in front of them, they review the case. They always tell them what to do, and I'm sure they study the case before they meet you. So,
yeah, but well, you know, they are getting court.
Right. They want to intimidate you, right?
Well, no, I think they really want to help us.
Okay.
Except we don't give them what they need to do. In coming after trust, expressing the trust.
Where was that you were quoting from?
That was on page 19 of the Practical Treatise on Law of Trust by Lewin. I put it on the website. That book, Volume 1 and Volume 2, is now on movingtitle.com on the...
So do you name everybody, let's say if you're in a court case, do you name everybody that has had some role in that case that you name them as trustee? The reason why I ask that is because even on this one case that I'm talking about, I mean, I have recused 4 judges, 4 magistrates, and gone through probably 7 different attorneys from the State Attorney General's office.
like recusing judge because all I'm doing, new judge, is just going to accuse him. I'm looking for recusing.
Oh, I know, but I didn't have any at the time. They just wasn't. And what I'm saying is, in naming, do we name every party that has had a hand in a case that we're trying to move via UCC1? Do we name them, or just naming parties currently?
Well, I would think it would be at the minimal you want to do the current parties that are involved. But you want to bring in some other parties and on the whole thing, you mean?
Well, they're all named as trustees.
Oh, I see.
Yeah, so I'm just thinking to carry it over to the UCC1. Should that be? We named the court, the county, the commissioners, several state agencies on the case, the judges, every judge.
Whereas I'm going to make say the judge and maybe the prosecutor, say the trustee on this, and give them the trust res, which is all that other stuff. I'll keep it simple.
Yeah. Well, the main party, because it's the Florida Department is the Attorney General's office, but it's through the state of, and then of course you're talking about that particular county, that particular judicial district, the chief judge, so on and so forth. So there's a few parties just on this one case. I mean, if you saw it, if I had an in-camera meeting with you, Christian, you would see what I'm talking about.
Well, keep it simple. Keep it down to a minimal kind of trustees on what you're trying to get settled. Just treat all those other trustees on that bond as being just plain old trust res.
Okay, all right, that makes sense. That makes sense to me. All right, thanks.
Yes, Christian?
Yeah.
And tying on top of what he just said, Lewin suggests that we use between 3 to 4 trustees. He says that 1 is not appropriate, 2 is okay, but between 3 and 4.
Okay, where's that at?
I'm not exactly sure. I was reading it this morning. Maybe.
Okay, what was the reasoning for that?
The reasoning was because one trustee, let's say he becomes capacitated, that would then restrict the effectiveness of the trust. And if you have 2, one person, passes on, becomes incapacitated, you have a backup.
Okay, that was a different context as to, say, we're trying to merge titles and terminate the trust. This is like for a total lifespan of the operation of a trust for a life, say.
Right, but I thought he was talking about trustees.
Yeah, he's talking about trustees, but in this particular case, if I just want something, settle and close this case, and it isn't going to be, the life of it isn't going to be very long. So I don't need to worry about multiple trustees because I'm not doing anything for a long period of time.
Right, and I got that. I was just saying that I thought you counseled him in the way of keeping it simple, and I was just throwing this out as a yardstick to have a number.
Oh, okay, yeah. Well, I'd even keep it simpler yet. I'd keep it down to a minimum of 1.
Okay.
Judge at least.
Okay. And then also, you were speaking with, I think it was Carlos, about a allodial title. Now, what would happen after that? Because my understanding is that once you have a allodial title, involves the grid of
a case that we've closed the title, merge the title, and close the case. The mortgage. But amending the close on the court so that we get it
to mean to the property owner now? Is he going to have services, or he has to contract separately for his own?
Well, that means that you really own the property, and you have a perfected again, and there is no way to be cleaned up ever again.
Right, I got that part. The thing is, though, who's going to provide his water or his...
The court is going to recognize that and close the case down officially.
So that now he owns the property.
Mm-hmm.
Okay. Now he has police, fire, water. He needs those services.
Yeah, you may have to make some contractual agreements between the trust to maybe get those back.
Right. So now, in this particular case of which you speak, are you saying that in this case you're going to merge the titles and the monies on the private side will be dispersed to this person through the LLC on the public side? Is that what you're saying?
No. This is just a particular case on a foreclosure that the case is officially kicked off in the county, but now we're working on the fact that it's going to be the official closure in the court.
So then, in lieu of taxes, he'll be still paying a fee for the services?
No. Unless he wants to.
If he wants those services, yes.
Yes.
Right. Right. Okay, thanks.
I'm the same subtitle, Daniel Ray in California. Yeah. The land ultimately is under the Grand Trust, which comes from the Creator, supposedly 6,000 years ago. Where does that fit into this? Because the county, even though that was originally put on the county, once that's merged, can we then go back and claim the original trust agreement? If you merge the titles, the trust is what's holding the perfect title from coming forward, and you do it all simultaneously. Okay. That then put us under the original trust, the Creator's trust. Yes, right. Declaration of Independence Day, my Bible. Yep. Thank you. Unalienable rights. Christian? Yeah. I've been looking at the UCC-1, and I'm trying to find under 7 where you would put the nomenclature change and... 8? Which number 8? Which one's the optional block? Okay. 8 is optional filer reference data. Okay, there you go. Block 8 then. Oh, okay. Now, on UCC-3, there is a place on 7 where it says change new or added information, and could you put nomenclature? Your 3 is based off your 1, so it carries forward. Okay. All right, so then you just put in nomenclature change, and then the nomenclature change would be creditor. Pardon? Trustee/grantor. Trustee/grantor. Oh, okay. So if you look up, was it block 5, which lists the actual changes like Baylor, Bailey? Which block is that? Block 5? Yeah, that's 5. Okay, Baylor, how does it say it? Is it Bailey, Baylor? Bailey, Baylor, yeah. And EE is your debtor, and that's also your trustee. I see. And the ORS is the grantor or the trustor or your secured party. Okay. So you got to follow the same sequence, your EEs and then your ORs. So it's got to be trustee/grantor or trustee/settler. Oh, okay. I see. Okay. And then make yourself a little block and put a check in there, and then put in that there nomenclature change. Oh. You put the little block first, and then make a check nomenclature change? And just like they got up in 5. Oh, I see. Okay. But now in 8, make it like trustee/settler and
wherever the little block is, put a check in there, and then right after the say nomenclature change.
Oh, okay. Got it. I see. All right. I had it backwards.
Then you don't check any blocks in 5. Right. You don't have to change 1, 2, and 3, whatever's worded there. It automatically changes because of 8.
Okay. So that would be trustee, grantor. Okay, and I would trust, and so then I would just check the grantor.
Well, make yourself a little square block that you can put a check mark in beside that.
Yeah,
like up above in 5.
Right. Mm-hmm.
And when you put a little check beside that, then your trustee/grantor nomenclature takes effect of debtor and secured party creditor up in 1, 2, and 3.
Okay. Oh, yeah. Okay. So you put trustee/grantor. Okay.
And in 8.
In 8, yeah.
You put a little square block there that you could put a check mark in. Just like they got it in 5.
Oh, okay. I see. Okay. So you. Oh, okay. I was thinking that you had to mark grantor, by itself.
Yeah, you're going to write in the optional block 8 there. You're going to put in trustee/grantor.
Nomenclature change.
And nomenclature change, yeah. And then you're going to put a little, I don't know whether the little block comes before the Bailey, bailor, or does it come afterwards? Forget.
Comes before.
Okay, so now put the little check block on 8. Put it before, so put the little check block, then trustee/grantor, and then put a little hyphen and nomenclature change. And then put a little check in your little block.
Okay. All right. Got it. Nomenclature change. Okay. Well, that takes care of that then. Okay, that one.
Now I've got notice filing according to UCC, or not UCC, according to trust terms. Excuse me.
Right. Okay. So then what you've got? Okay, then now you can go back up to the top and figure out then anything that's debtor is trustee, anything that's grantor is would be creditor.
Secured party, yeah.
Yeah, secured party. Right. Okay. All right. Well, this is becoming a lot clearer all the time. Thank you.
Hey, Christian, this is Eric. How you doing?
Hey, Eric. How are you?
Great, thanks. Hey, and the gentleman that was just speaking, he might have misspoke, and we're all wondering about this. He said trustee/grantor. Should that be grantee grantor/beneficiary? Do we want to have those two, the grantee, the grantor, and the trustee, in the same as one designation, or would that actually merge?
The grantee, that's the same as trustee.
Right, grantee/trustee, right?
But if, just like on 5 there, they have Bailey/bailor. So Bailey is really your block 1 and 2, your debtor. And bailor is really your block 3 secured party.
Right.
So now if I'm going to do block 8 as trustee or grantee/trustor, or it's going to be the same sequence.
Okay. And I recently did an example of this from the recording we talked about back on the 8th, and I emailed that to you. And I did it off of a Florida UCC. So there are some different UCCs out there, obviously UCC 1 forms because in Florida the alternate designation is actually Block 5.
Yeah.
So is there one out there that we can use as a model that'll help us?
Well, I think everybody takes the national form, so the national forms would probably use them.
So every state will use the national form. So in any event, we can use that as our standard for a model.
Yeah. Mm-hmm.
Okay, good.
Is this still speak? The form that I was referring to is the National UCC Financing Statement, and that's what the state of Virginia is using. The national, it's the same as the national. Right. They'll either take a national or your state local form. Yeah. Yeah, and the one I was referring to is the national one. Right. Okay. But here in Florida, the Florida form is a little different from the national form. Well, I was just letting you know that so that you would know which one I was using, so that it'd make it easier for you to refer to what I was doing. Right.
Great. Yeah, thanks. And I did a model off of the Florida form, so if you do happen to find that in your sea of email, I could also do a model for everybody off of the national with all this stuff that we've been talking about tonight.
Really, if you understand what you're doing, it doesn't make any difference what sequence those blocks are in. You can take those blocks and make them out right.
Good enough.
That's just do is think about what you're doing.
Okay.
Optional block is block 7 or 8. It doesn't make any difference. If I know what I'm doing in the optional block, then I can put it anywhere.
All right. And some of the things that the last time I had an opportunity to ask about this form, I was wondering about, and I asked you, and you said go back to UCC 9-500 and look in there, maybe some of the answers you can get out of that. And that was under, for example, under 1 and 2, the blocks in there that are D, E, F, and J, F and G, which are tax ID, type of organization, jurisdiction of organization, and organization ID.
Mm-hmm.
And Terry and I, in Louisiana, were talking about this kind of stuff earlier, and we were talking about the rules of filing that we were reading out of UCC earlier tonight. Now, because we're changing the nomenclature, does the normal rules of the UCC apply towards them accepting a filing? If we leave those D, E, F, and G, if we leave them blank?
Well, I don't know if you're going to leave them blank. Some of those things are necessary.
Okay. So, for example, if we take a court case and we turn the case number into the res, and we'll talk in that context for this in order to understand what we need to put for the tax ID number, the type of organization, the jurisdiction of organization, and the organizational ID, where would we get this information from in order to put onto here when we claim that case number as our res?
There's examples in the UCC of what to put in there. They give the jurisdictional examples like United States.
Okay. Do you have your UCC handy where we can all go over this together in the UCC to all get a good understanding of what's put in there?
No, I don't.
Well, I have mine if you want to kind of direct me towards the place, and I can read it for us. I'm in 9-500 now. I can tell you the titles of the different articles and let you already know, or the different designations within Article 9.
You have to leaf through the official comments someplace and find out where it's, picking that out. I'm not exactly remembering where that's at.
And if anybody else on the call wants to jump in, if they're familiar enough with the UCC, that might help us get this information on the table here, that'd be great.
Okay, so what you're saying is that you're going to
unmuted.
Unmuted the information that we need to put in the UCC1 at this point. Yeah, they give you examples in the filing of the UCC and the official comment gives you the information. Okay. Well, I have an example. Well, I have the UCC. I have the UCC with comments
I can hear your recording, but I cannot
and so
hear you.
And I have all of them up to 10. So they would be in 9,500 then. Pardon? You have it on disc, in digital form? Yeah. Oh. Hey, if you want to post that on Fort Share, we would all love it. Is it searchable? Yeah, it's searchable. Yeah, it's information that I got from Sam Bowman. Yeah, I wasn't aware whether they had a searchable copy, because if they had a searchable copy, that makes things a whole lot easier. Well, if you want me to send you one through the mail, you can take a look at it. How many CDs? How many CDs? Huh? Oh, it's on one CD. But when you go online, excuse me, when you put it in your disk drive and you're online, it'll actually, everything goes right online through the disk. Yeah, that would be great to have a copy of that, because that would simplify my research a lot. I'll send you one if you give me your address. Just give me send your address to my email. Really, you could do you send it, or even through Skype we can do a transfer of a larger file, since it's under 700 megabytes on one CD. Well, I've already got the CD copy, and it's easier. It's easier for me to just send it through the mail, and then that way you can do whatever you want with it. Okay, well, send me an email if you got that available. And
Yeah, I can hear you and him twice.
Contact with you. All right. Okay. All right. But back to the UCC, I actually have the UCC with official comments here, so if we can find, maybe if you can look on his for what we're looking for here, and then we can even read out the official comments and get this straightened out and get the information, these examples out of the official comments on what to put there. That'd be great.
Do you want to say something?
Under 9-503.
So why did you call?
Talks about the name of the debtor of the secured party.
Oh, I'm dialed in with the phone.
Right. Under number 2, it says debtor's names, and it
now.
starts in there where it starts giving you examples. It says under subsection A4A.
I'm hearing it twice.
Talks about the term organization, and talks about business trust, and personal trust, and governments, and estates.
Just dialed in.
And in 3, it talks about the secured party's name, it gives examples. Okay, under 9-505, then under section 3, it says changes from former section 9. It talks about bailments there. Under A, under the actual text code there, it says use of terms other than a debtor and secured party. In the code section right there, it says a consignor or leasor or other bailor of goods or licensor or buyer of payment intangible or promissory note may file a financing statement. Under section 9311A, using the terms consignor, consignee, leasor, leasee, bailor, bailee, leasor, leasee, owner, registered buyer, buyer, seller, or the word similar import. In other words, grantor, grantee, settler, settlee. Instead of the term secured party and debtor, all you guys got to do is read this stuff. It's in there. It's in there. So, for example, under 1E and 2E type of organization, if we go back to the official comment under 9503, second paragraph under number 2 where it says debtor's name, subsection A4A essentially follows the first sentence of former section 9-4027.
Section 1-20128 defines the term organization, which appears in subsection A4 very broadly, to include all legal and commercial entities as well as associations that lack the status of legal entity. Thus, the term includes corporations, partnerships of all kinds, business trusts, limited liability companies, unincorporated associations, personal trust, governments, and estates. If the organization has a name, that name is the correct name to put on a financing statement. Mm-hmm. So what can we glean from that? For example, if it's type of organization and it's a court that you're in for this case, are we going to put, for example, Duval County Court? Is that what we're going to put?
Yeah, however they have their themselves down as doing business as.
Okay,
they have to call financial department and see how they're doing a DBA.
Okay, that really helps a lot, because that was one of the questions. And if we can't get their tax ID number, because I don't
give you a tax ID number.
All right. Do you have any tricks for us to get them to give that up?
Just tell them that it's required by law. I'm making out some IRS documentation that's required by law.
You unmuted. They're reluctant to give that up, right?
Hey, Christian. This is Terry in Louisiana. Related to what y'all are talking about, it says in 9-516, if you don't know the ID number, you put the jurisdiction of organization. It's required.
Right.
So that kind of sounds like it's not necessary to put the ID number if, for example, you can't find it.
I can there refuse to, when I make out the documentation, you refuse to give it to me.
Right.
Now, if you refuse to give it to me, the IRS says it's different. You're supposed to give it to me. I guess you're in breach of something with the IRS, then, I guess.
Right. They can't hinder us filling this form out by lack of information. We have some outs, it looks like, in the UCC.
Yeah.
And one little trick I can share with you guys, with everyone on the call, is that you call up their finance department and say, I need this for my tax return, my accountant's asking for it, and it might be something they'll give up just because it's not you, it's a professional that's asking for it. That might be a little way to get around it if you are running into some resistance.
Yes, right. I mean, you don't want to go in there with a hammer and expect them to give it to you, the thing turned off and won't give it to you. But if, give some kind of colorful way out, they should give it to you.
I've tried a few different ways, and some of them will and some won't. You just have to take what you get.
Well, I'll point out the fact that, hey, by law they're required to do it, and I'm going to mark that they refused, and then the consequences upon them. Then you go, that's by notary.
Yep.
So for the jurisdiction, we just simply put USA, and we're fine with that.
Yeah, I forget exactly where. It gives examples in there of the jurisdiction things.
I think that's under 9-516.
516?
Yeah.
Terry, is that in the comments, or is that actually in the...
Yeah, it's in the comments there.
Okay.
Yeah, I would read that whole 500 section and just kind of enlighten y'all.
Yeah, one of the things I'm concerned with is that section 9-516, because it talks about the what constitutes filing and effectiveness of filing, and reading various things in there. For example, in the collateral statement, if it's not sufficiently understood, or if it's not well enough understood, they could declare it unacceptable or ineffective. I understand we're trying to use colorable words to get our point across or get everything included, but
if I did electronic filing, I wouldn't have any problem.
being that they wouldn't have an opportunity to reject it.
Right.
But then you're dealing with effectiveness, which is something that could probably be.
Well, keep in mind that they're under UCC. They're saying, okay, to make an effective UCC filing, but I'm not doing a UCC filing.
Okay.
I'm doing a non-UCC filing.
Okay, that's one of the questions we have. Does all of this matter if all we're doing is a non-UCC filing and effective notice?
Mm-hmm.
Does it matter if we leave some things blank that the UCC says we need to have filled in, or else it's not effective?
Well, I would make sure that I would fill in the necessary blocks with something.
Yeah, even if it's unknown.
Right. All right, so this generates some questions about the statement that we put in collateral block 4, as by grantor, as owner of all right, title, and interest with a non-negotiable instrument claim. And Terry and I, we were talking about this earlier. And Christian, you and I were talking about this recently about how we don't necessarily want to go in chambers and present them any trust indentures. Well, the word instrument, by definition, is a written document. So if we're in camera and we're claiming, we're expressing, and we're providing our material evidence, what do we want to use as a written instrument to present? You have like a letter rogatory that you told them what to do? Okay. So simply orders, for example. Then an oral trust being, okay, I gave you my pen, I want my pen back. Do I have the witnesses? Do I have some kind of documentation, some kind of letter rogatory or something? And if we were to use a non-negotiable instrument, that could certainly be the indentures if we were to write them, correct? Yeah, because under, say, like 3.115 of the UCC, even though I'm not using UCC, but I'm using the intent, it was an incomplete instrument to be later on completed with additions of words. And if we were to use, pardon? So your offer that you sent me for debt or creditor, I turned into a trust by the addition of words. And those words can be oral words. Since it's trust terms, and it's private, it's not going to fall under the statutes of frauds, where it has to be written. So if we were to, so I guess the word instrument is a word that's more subject to the statute of frauds. Yeah, on the statutory trust side, yeah. Okay, because we're using the word instrument in our UCC1 for our claim, I'm wondering if we have to be concerned that our feet are going to be held to the fire when we use that word. Yeah, that's why I like to keep things purely trust on the private side. That way you're not using, UCC numbers and statutes and codes and things that you're going to be construed to be under statutory trust or statutory law. So even though we use the word instrument, once we get in camera, because it's our law, it's our direction, we don't have to provide anything in writing, even though we use the word instrument in the public. That is only there to play the game to get in, really, yeah, right? I put a caveat on that, that all definitions are for the understanding of me, the grantor. Okay. That helps Terry and I out a lot, because we were really picking every word about this statement apart earlier and figuring out where if our feet are going to be held to the fire somewhere. But hey, you know what? That's your law form.
Okay. So that helps a lot right there. And now where this progresses to is, for example, if we are in a mortgage case, we were talking about if it was a case that was already in court, and we had a lis pendens filed against us, as here in Florida is, and considering the statement says, with all attachments and proceeds therefrom being held in the private. Well, so if we take that case number and we turn it into the res, that promissory note from that mortgage now becomes part of that res, which is, it's all-encompassing when we utilize that case number, correct?
Right, everything generated is done in secret in the background with all the bonds and everything else. Bid bond, performance bonds, payment bonds, whatever else they got attached to it. All proceeds therefrom, all that, everything else is all yours. All you got to do is prove where it's at, find out where it's at, and go get it.
Well, that brings up a very interesting question, because I've been going around and around with my mortgage company on getting them to prove to me where the note is at, and they keep telling me that, well, first they tell me that they don't have it, and now they tell me that they do have it in writing, and I'm getting the hey, don't look at me, look at him kind of approach from them, which I guess most people are encountering that nowadays.
It doesn't make any difference who's got the note. I'm the grantor, and I issued it. It's under special deposit. Now give it back. If you don't give it back, you're in breach of trust. Give it for breach of trust. Stop playing their games.
Okay.
Look, I'm the big dog here. I'm the grantor. I'm the 900-pound gorilla. Let's get into court of equity, and I'll show you.
Okay. So if they want to play that game, they want to breach, then they can go ahead and pay the price.
Yeah, make a demand for them to surrender the note. I want it back. If you can't, you've commingled the funds, you're in breach of trust, and we got a lot of problems here.
So at that point, they're really just going to want to look for a way to settle at that point.
So once you start coming at them with an action.
So your anticipation is you're actually going to have to file an action in court against them.
You're going to have to take the fire to their roof, and when you start the fire on their roof, I think their attitude's going to change.
Okay, so in the workshop, or we
doesn't cut it with them. They got teams of attorneys that are willing to fight you. Only when you start making the thing and you come at them, just like the SNEP case, come at them in a court of equity under breach of trust instead of contract debtor creditor law.
Okay, so in the workshop, are we going to put together an action we can file for breach? Because that sounds like that's going to be a key part of this.
If we get that far, let's put it that way, in the first workshop, let's put it that way. We'll see how far we can get.
Okay. Well, I guess you could say that would be a goal.
Yes, right.
All right.
We'll have probably multiple workshops, continuing going on. It'll be like workshop 101 and, 201 and 301, like intermediate, advanced, whatever.
Okay.
I'll start someplace, so.
So if we were to try to claim our special deposit without a court action before it ever got there, what process we want to go through to notify them there's a trust to express?
25-06.
And that's really our only option. By notifying them in writing, it's not going to do any good, is it?
I don't believe so. No, I don't expect these people to roll over and play dead. Not without some kind of action against them.
Okay, so really our best hope is just to construct our documents in the first workshop, and then wait the 120 days and get our IMF corrected, and then go for the DIP hearing. Unless we just want to stop paying and take a chance on a legal action and deal with it that way, right?
Yeah, you may get at least 10% success rate, maybe even more. To start out with.
Okay.
Even if you did it without, terminating the master trust in an IMF file.
So So you really don't, beside that, so you don't really see any other way, just in contact with, for example, the lender directly before we correct the IMF, do you?
Not unless you were known that you have the big stick by you made an example out of somebody else, just thrashing the hell out of them.
And you're really going to have to know how to conduct yourself.
To them, and they don't want it done to them now. They're going to change their tune, and maybe they'll say, "Okay, let's do a settlement here." Okay, your settlement is I want the house plus I want treble damages. Period. And you guys can have the note.
Okay.
So ideally, we want to correct the IMF before we even attempt this.
Ideally, yes, but maybe some of us don't have any choices. You know, at least I could say you could count on at least a 10% success rate, and probably more to start out with.
Well, that's a big risk.
Well, it's no more risk than any other method.
Oh, well, granted, yeah. That's why I'm not trying
Well,
any other method.
Go ahead, Nick.
So that's why I'm not trying any other method. Don't like those odds.
I know, neither do I, and that's why I've searched for another method that's better, because after 20 years of doing the debtor, creditor, and redemption and except for value and all that stuff, we should have a higher success rate than 10%. Something else is governing this, and I found it under trust. It's a protective, discretionary trust.
I'm with you on that.
Now I finally understood why we don't have a success rate and a remedy. And now we can understand what the problem's been, and now we can make steps to correct that and terminate that trust. And make the corrections, and so we can get a higher success rate.
Well, part of the problem I'm having, and I'm sure most people listening to these calls, is that I don't have all the steps in place to be confident that what I'm attempting to do is the right thing to be doing. Don't want to be caught
Not
off
any
guard.
gun or any pressure, then I would wait until I got confident in my mind that I knew what I was doing before I did it.
Yes.
Because any time you're under pressure, you make mistakes, and sometimes the mistakes are fatal.
That's what I'm trying to avoid, the fatal mistakes.
Hi, Christian, it's Rod from the UK. How are you?
Good. Go ahead.
Christian, there's a couple of us actually been working on a committee here.
You did.
And if we've got a bit of time, I just want to run this past you if we can. We're looking at actually getting hold of a mortgage redemption statement, which is basically, as it comes into us, a debt title, which we want them to turn into an asset title.
So that would be a statement of accounting?
Yes, indeed.
Okay.
Obviously then doing a UCC1 and a UCC3 and returning the now asset title back to the trustee, which we're going to make the CFO or the CEO of the bank concerned. Then coming in from a beneficial point of view, merging
the original note on there already? This is pertaining to a mortgage, I would assume, right?
It's reference to a mortgage, yeah. We have a slightly different situation here in the UK. We don't actually have specific mortgage notes as you do in the US. It's kind of coloured up into probably a combination of the mortgage application and the mortgage offer. But we don't actually have a specific note per se. So the assumption is that we would take this basically this debt title, turn it into an asset title, send it back to the bank as the trustee with an indenture, and then some stage later, from the beneficial point of view, then merge the beneficial title and the legal title with the trustee, therefore terminating the trust and hopefully dispersing the funds.
Yeah, make sure I have a special deposit, which is segregated trust res.
Well, we're looking at making the asset title, which would be the special deposit.
Yeah, it has to be segregated trust res. In other words, if I want my pen back, give you my pen, I want my pen back, you have to, in order to give me my pen back, you have to segregate it.
Well, within the terms of the trust indenture, we're making a note in there to that effect.
Okay.
Yeah? Okay, it's a bit of a loaded question, but in principle, as a process, does that kind of make sense?
Yes.
Okay.
But make sure you have 2 records for the claiming and 2 records for the transfer.
Yeah, okay, so we're really clear. I think we're clear on the UCC 1, UCC 3. And as far as the notices go, that's fine. On that point then...
Yeah, but you would also, what we do here is we do it also, on a 1, we do a county recording, and with the 3, we do also a county recording. So we have 4 records. We have a UCC 1, a UCC 3, and 2 county.
Yeah, that's fine. We've been working on public notices here as well, so I think we've got the UCC 1, UCC 3 covered, hopefully. Going back to the private doc pact, what physical documents do you feel we need to keep in the private? I'm assuming at this stage we would need to have some documentation that proves the trust formation, our intended purpose.
Notices.
Okay. Do they need to be authenticated in any way?
The notaries would authenticate the private documents, yeah.
Okay. So it would actually make sense to actually have those notarized.
Yeah, or you could have 2 witnesses on each one.
Okay. Okay, that's cool. Next question on that case then is, once the trustee is actually in possession of the trust docs and the trust res, obviously the beneficiary needs to move his title to the trustee to merge titles and therefore terminate the trust.
Well, you already did that because the return of the document would be the title to the asset. It is really the beneficial title. The deposit would be the title. It's like simultaneously.
Yeah, but am I right in thinking though that the grantor would be right? Basically, that documentation pack would actually be leading from the title of grantor, not beneficiary, and it's the moving of the beneficiary's beneficial title to merge with the legal title, which then terminates the trust.
Okay. Yeah, I agree with that.
Yeah. Well, the route we were going to take was that the documentation, the indenture, the trust res would be sent to the trustee from the title of grantor, and then at some later stage, which could be minutes, hours, or days later, the beneficiary would then inform the trustee that he no longer wants his title, assigns it to the trustee, so therefore the trustee has perfect title, therefore terminates the trust and disperses funds.
Mm-hmm.
Now, my question on that point would be, what would be the best method of the beneficiary telling the trustee that he doesn't want his beneficial title anymore? Would that just be a simple notice, or...?
Again, another 1 and a 3. As another entity is going to do another 1 and another 3 with the county recording against it to prove that he claimed it and transferred his right.
So the beneficial entity would actually do a 1 and a 3, yeah?
Right.
Okay. That kind of makes some sense. Then finally, on that one, are we making the assumption that the trustee himself will know what to do once he's actually got the perfect title, or would the grantor need to notice him to that effect as well?
Well, the trustee only has a duty, per se, of the grantor's will and intent, and you're either going to have to give him the will and intent either orally or in writing.
Okay. Well, just backtracking slightly in that case, I'm just curious about the beneficial title, moving beneficial title with UCC 1 and 3. We've kind of made the assumption at this stage that the grantor is actually going to be effectively the strawman entity. the beneficiary being the real man entity. And the reason
the public is fiction's entity, so it would be a fictional beneficiary, a fictional grantor, backed up by a real live man.
Okay. Okay, it makes sense.
In change, real man can show up as say, the beneficiary.
Yeah. Okay. Okay, cool. I think that's pretty much answered my questions in that case. But in principle, you're happy that the process, the remedy looks to be workable.
Yeah, you have to keep in mind the separation, between public and private, and make sure that your thinking corresponds, what you're doing, whether you're operating in the public or whether you're operating in a private, and then being able to switch your mind.
Okay.
Don't we have to revoke the power of attorney too?
Power of attorney for what?
On the promissory note.
His situation, he didn't have promissory note. He said,
okay.
Well, there's probably a promissory note in place. We just don't have it titled or have access to it in the same ways that you would. I mean, the feeling is if we go down this road, if we get a redemption statement, which is basically a debt title, create an asset title out of that debt title, while also giving a specific reference number, doing a UCC 1, UCC 3, giving that to the trustee, then getting beneficial title and merging titles, therefore terminating the trust. Basically, the mortgage balance would be zeroed when the funds are dispersed, but the original trust, the original promissory note trust, is actually still in situ. And the idea was then to go back and look at reclaiming everything we can with the original promissory note.
Mm-hmm. Yeah, you could do that.
Yeah. All right, terrific. Listen, really appreciate your help on this one, Christian. Much appreciated.
Philip has mentioned about the rescission. We use the rescission for, according to how we're using it here in the mortgage foreclosure or the mortgage escrow closing. Rescission of the fact that the power of attorney was granted to the bank, and the bank assigned a trustee, and the trustee was really the escrow closing agent, the title company. And we needed some way of getting a rescission authority through a debt validation. But once we got the debt validation, they refused to respond, gave us the dishonor, gave us the authority to do the rescission. Now we got the power to rescind the power of attorney that we gave the bank, and therefore we can negate the fact that the trustee was the title company, and we can then assign a new trustee, and we would make the new trustee the bank, who is also the beneficiary. So now they're both entities in one. So now they got problems because the titles were merged into the one entity, the bank.
Okay. Yeah.
Hey, Christian?
Yeah. Go ahead, Carlos.
I have something kind of interesting right now. My brother bought a condo about 5 years ago. He took out an 80-20. Okay, 3 months later, he paid off his second loan. Yes, he had the cash. He paid it off, about $70,000. So they send him all these documents. He put them aside, right? We were going through those documents yesterday, and we noticed that on his note that he paid off, the second loan, it's been stamped 4 times. It says pay up to the order of without recourse. We know that 4 times. But what makes this interesting, the fact that his signature is not his, 100%. Right?
His signature is not his?
Somebody forged.
Oh, okay.
See my point? It's been scribbled. It's been they screwed up. They wanted to fix it, and they went ahead and processed it.
So they, yeah, well, see, you gave them power of attorney to sign your name for you, so.
Okay, so, I mean, is that legal?
Yeah, they got your right, they got their right to sign your name by combination signature rights, yeah.
Okay.
You gave it to them.
So case closed there, huh?
Yeah, yeah.
Okay. So we gotta start back over again and go through trust.
Mm-hmm.
Right. Thank you.
Christian?
Yeah, well, one comment back on that, if it's been processed 4 times with some other endorsements, then that means it's been negotiated 4 different times, and it's been cashed 4 times.
I know. See, but
how about
getting
the proceeds from all that?
Yes, that's our plan.
Yeah.
Thank you.
Okay.
Hey, this is Michael. In regards to what Eric was saying, using the court case as the res, the trust res, that would also apply to an account number or anything like that too, would it not?
Yeah, case, account.
And then also last night when you were reading out of page 19, and I saw the last paragraph where it says that we have to go to see a quote-unquote a judge or a trust judge. And this is in reference to the Declaration of Independence, because the D.C. court, the little D.C. court in D.C. is in control of all the courts in the U.S. Would we go in there in regards to the Declaration of Independence, is asked for a dip hearing?
Might be able to just do a dip hearing just in the Treasury IRS.
Okay. Because I was just thinking, they're going to try and stop us no matter what, and I think it's going to have to end up going into a court proceeding, and, behind closed doors, in-camera door, with the D.C. court judge.
Right. I came across here, I was reading last night, it was talking about the capacity and guardianship law.
Yeah.
Because I was were you on last night's call?
Yes, I was on. I was speaking with you.
Yeah, I was talking about that mutandis.
Yeah.
They were changing. Let me see if I can find it quick here. On page 4 of the treatise on the practical application of trust, we're talking about their trust applicable to channels, or trust applying to channels. This is the doctrine of the principles of mutandis, the doctrine to construe and to change the right to sue on privity and interest of the beneficiary was not to be assignable. Mutandis, all necessary changes having been made with the necessary changes. And what was said regarding the first contract applies mutandis to all later ones. And that was out of Black's 7th that was out of Black's 8th there. But Black's 7th and Black's 4th, which uses the same definition, was with the necessary change in the points of detail, meaning that matters or things are generally the same, but to alter when necessary to names, and that brought another, right after that, I thought, the upper and lower case names, when necessary as to names and offices, right up beneficiary trustee, I thought, and the like. And then I did a Google search for that, mutandis, and I was looking for the case definition that they listed on that, which was, let me see where it is at, Houseman versus, where's it at? Versus Waterhouse, 91 of Division 850, 192 New York Supreme 249-251 case. I was trying to find that case, and I came across this capacity and guardianship law, which was making reference to that case, and it was pulling up Chapter 1, which was capacity, and we talked about capacity before under Gilbert's Trust on page 33 under Section 125 and forward, where the trustee had the right to have and to hold property, as well as anybody can have the right to have and hold property, but the trustee, in order to administer the trust, had to have capacity to do so, and that capacity couldn't be incompetent. So an incompetent person can have the right to have and to hold property, but he cannot administer a trust. So he can't be trustee. So then I talked about this capacity under number 1 through like 24, and number 1 was just capacity with respect to rights and obligations, and every person shall have a capacity to have having rights and obligations from the compaction of his birth until his death. But then it comes into number 8, where it's talking about the declaration of incompetence, a person who, by reason of mental illness or a defect of mind, and the defect of mind could be the misconstruement because you don't know or understand there's a trust in place here. So a defect of mind is incapable of looking after his own affairs, may, upon application of his spouse or of his relatives, or upon application of the Attorney General or his representative, and after such person or his representative, and I thought that representative would be the straw man, has been heard, since the straw man is a dead entity, can't speak, he obviously falls into dishonor and is incompetent, and he's declared by the court to be legally incompetent then. And then in number 10, it talks about the revocation of the declaration. So this is getting to the point I'm trying to make here. Where the person has been declared legally incompetent, the court, just like you said there, we may have to go into the court of D.C. and maybe get a revocation of the declaration here. So where a person has been declared legally incompetent, the court may, upon his application or upon application of his spouse or any of his relatives or of the Attorney General or his representative, or after hearing the legal incompetent person, revoke the declaration of incompetence if it appears that the declaration ought not to have been made or that the circumstances which led to its making no longer exist. In other words, you've now become sent here, you now know and understand that trusts are operating the whole thing.
So all we have to do is a revocation for the Declaration of Independence if we have to go that far.
Possibly. Now I thought, okay, your actions override your words. If you start acting like the trustee with knowledge and understanding, then you're going to revoke your incapacity. And if they see and you can get certified that you are acting as a competent trustee, then you're no longer incompetent.
So you revoke that in the court?
No, just by you acting like a trustee should be acting, because your actions speak louder than your words. So when you start acting as the trustee, because you said in your 1040, under your self-appointment, under that you're trustee, then when you start acting like the trustee should be acting, and you don't understand that this is a trust, then I think it's an automatic revoking of it, revocation, yeah, by your actions.
I see. I just wanted to go over that one more time. Thank you. Appreciate it.
Hey, Christian, last question.
Yeah, go ahead.
Okay, the fact that we gave him the power of attorney, did we let him sign in our name?
Apparently so. You have 4 different signatures that you let them sign in, with your name.
Yeah, if I give you my power of attorney, are you going to sign my name? Or are you going to sign your name? You have my power of attorney. That's my question.
Well, if I have combination signature, right, yeah, I should be signing maybe a little bit different way.
Yes. So that's fraud. That's my question. That's my statement.
Yeah,
if I give you power of attorney, I hope you don't sign my name. Right? Makes sense, right?
Well, accommodation signature, right, which is, 3-40 something or other, 419. The example is my restricted accommodation signature, and then you sign on the signature line by, say, John Henry Doe, and then underneath is, say, the actual party that you're signing for.
Right. I don't think it's normal if I give you my power attorney. It's just an example, obviously. If I give you my power attorney, you're going to try to copy my signature. Makes sense, right? Am I lost?
Well, I should do it technically according to 419 there. I should sign by, and then your name, my name, my signature, and then the below line should be in print, should be the person you're signing for.
Yeah, exactly. That's what I understood for 20 years. My question is this. When you try to copy my signature, isn't that fraud? That's my question.
Yeah, because that gives an indication that you're signing under a power of attorney, and then you need to bring your power of attorney in.
Right, okay. Well, at least I can put up a fight.
Yeah, you probably got a good case because, it'd come at them under trust.
Right, yeah. I'm not looking for fighters. I'm looking for solutions. See my point?
Right.
All right, Christian. Thank you. Great help.
Anybody else have a question? State your name, where you're from. Hey, Christian. Yeah, who's this?
Eric.
Eric, go ahead.
Hey, one of the things that Jerry and I we've been talking about is making sure we understand where the boundary line is, where CCI actually begins, because we talk a lot about claiming with our public witnesses. But where does the line actually, where is it clearly drawn where CCI actually exists? Or what CCI actually is?
What it actually is, any act or deed of the real man is really CCI information, or trade secret information. We got the Black's Law definition of state secrets. Let's see if I can find that quick.
Unmuted.
So the notices in the UCC 1 and 3 filings are not CCI information.
Yeah, the 1s and 3s are public notice.
Right.
And the counties are public notice. It comes out of a public record. It's public notice.
But a protective order would be CCI that would only be heard in chambers?
Well, a protective order is a device that sets up the CCI information.
Okay.
A public motion that tells them, I got, CCI information here.
And that's presented on the public side of the court?
Yeah, the protective order is, yeah.
So the revealing of your trust res would be CCI information, or the contents of your trust res.
Reveal it on the public, because if you do, you waive it.
Well, what I meant to say is the contents of your trust res is CCI.
Yes, right.
And that's only discussed in chambers, and it can be verbal, or does it need to be in writing as well?
It can be verbal, yeah.
So you think a judge will accept that as a verbal statement whenever you get in chambers and then respond accordingly?
Well, it's best to have a witness if you can, or a record, yeah.
Right.
That's why I like records or witnesses.
So you can basically put all this in documentation, bring it in chambers, have him read it, ask you whatever questions, all of course in private, and then expound on it if necessary, but he would have enough information in writing to make a ruling.
Yeah, as long as the necessary elements are there for, proving the trust, intent, purpose, parties, specific res. And then one of the methods of transfer.
I have a question about the methods.
It's documented, and you got proof of that, then you got to trust.
Okay. And that documentation being the notices and the UCCs?
Yes, the notices, right? And then when you come in with the actual documentation that you, like the green cards and the signatures, there's the proof that, they signed for it, they got it.
That being the opposing parties that you gave notice to?
Right.
Is, in the methods of creation, is declaration and claim synonymous?
No. Claim is usually, on breach. The trustee is going to be breaching, or somebody's going to be breaching, and the beneficiary is going to be bringing the claim.
So when we make a notice of claim, and that being on a notice that we file in the county, and the UCC1, that is not a method of creation of the trust. It's not until we do the transfer that the trust is created, correct?
Transfer of trust property in a non-comminglable form by special deposit, say, is the actual formation of the trust.
Okay, great.
That's been 3 years prior to your notice. So the actual notice, say it today, is pointing to 3 weeks ago that I actually transferred property, or 3 years ago.
So that would be the notice filed in the county. We could make the statement that it was transferred at the time of closing, for example.
Well, I don't want to put too much detail on the notice.
Okay.
We have a 3-line nomenclature that we've got that we worked up.
I got you.
We went over some past shows.
I got you, yeah. But somewhere down the line, it's going to have to be told, probably to the judge in chambers, that that's exactly what took place at the closing.
Right. Yeah, you got to get him in chambers. He's got to take his robe off, be in chambers, get into equity, and then you can bring in the truth. You can bring in the private substantive rights of the real man. There's where form, process, and procedure doesn't mean anything. It's where rights means. That's where equity is, and that's where trust is.
Okay, great. Thank you.
Well, you mentioned on a previous call where the guy went into chambers in California, and the judge specifically asked, I forgot what he asked the guy in chambers, but he kind of messed up his whole trust. And you mentioned something, but I forgot the wording that you said, what he should have responded to the judge. Do you remember that?
No, I can't say that I do. I don't remember.
Well, he was on the call last night. He's the same one that, created his own birth certificates and all that stuff, just to jog your memory.
Well, probably what happened is the judge started asking questions instead of the guy ordering or commanding or directing, and as soon as he gave that up, the judge knew he had him.
Oh, I think I remember now. He said something about statutes and codes. And I told him, you shouldn't be using statutes and codes in chambers. You should be using equitable terms, which are maxims and law.
Yes, that's what it was.
The maxims and laws can't be used on the public side, but maxims and laws are really good for the private man because that's his substantive rights.
As soon as he cited statutes and codes, he bonded himself to them, didn't he?
Yeah, he commingled the trust immediately because there he was in chambers. He brought in statutes and codes from the public, and he commingled the trust.
So he waived the CCI, didn't he?
Yeah.
Yeah, it seems like everybody out there is talking about maxims in the public side of the court, and they're no effect.
Right. Now you know why.
Yeah.
curtain gets pulled back.
I've seen too many legal documents try to be presented on the public side, and they quote maxims all over the place, but it doesn't result in a ruling for them.
Yeah, that's the state secret. A governmental matter that would be a threat to the national defense or the diplomatic interest of the United States, if revealed. They can't have that in there. It's information possessed by the government and of a military or diplomatic nature, the disclosure of which would be contrary to public interest. State secrets are privileged from disclosure by a witness in an ordinary judicial proceeding. And I want to put in there by caveat, by protective order.
All right, I got a question. When we, for example, we gotta protect our res, which is what we can only reveal as with our substantive rights in camera. So, for example, we get pulled over for a speeding ticket, and the cop says, "Sign the ticket, or else I'm going to jail," or else you're going to jail. And your signature in this situation is the res, correct?
Yeah, I'd be happy to sign that. Give me that. Let me sign that once.
Okay.
I'll be glad to sign that for you.
So that's going to be worth a lot.
Okay. And I got a bunch of stuff to talk about this, but he says sign the ticket. So your signature becomes the res, and then they go ahead and they file that ticket into the public record. Mm-hmm. So now they've exposed your res, which is your CCI, into the public.
Okay, but now from that point on, now I can start, doing something about it by creating records of a trust instead of a record under debtor-creditor.
And that wouldn't be in the public.
Right.
So you've taken it out of the public and put it in the private.
They construe it to be debtor-creditor until you go ahead and correct it with trust, and at any point we can correct the credit debtor.
The building that gave me that offer, that ticket, that was an offer for debtor-creditor, or it was an offer for a bill in equity.
So ideally, you could go back on any past traffic ticket and form a trust.
Yeah, if I formed a trust, then it would become my bill in equity. I'm going to give it back to them because they're construing me to be the trustee, and I'm going to say, no, I'm the grantor, approve that, and then you guys are the trustee. I'm giving you the trustee papers to make the receipt of the documentation, which was my bill in equity, which is the asset title, which represents the counter to their debt title that they gave me as the offer.
Hey, Kristen, this is Steve in Northern California.
Mm-hmm. Go ahead.
A perfect example of that is like the title on your car. Is you get a certificate of title and the state holds the title. Can you demand that you want to trade in your certificate of title for the title?
No, just
they're loaning it back to you, or they're forcing you to pay registration fees every year, and they're not giving you title. You have colorable title, and they have the title. That's like stealing your title.
Yeah, but you never ask for it back.
So if we want it back, we can just say we want it back, right? Just go to DMV and say we want it back, and they don't give it back, they say it's stolen.
Yeah, I would order it back. Order the surrender of the trust res.
I got a question on that, Christian.
Pardon me? Claim and fruit trust.
So you call it a trust res. The certificate, the real title is the trust res, and the certificate of title is trust res. You want to swap one for the other.
Well, I don't want to swap one for the other. I want to merge the two of them and then not get the real thing back.
Okay.
And you do that through your notices and UCC 1s and 3s?
Claim and merge the titles.
Right.
All right. Well, I got an interesting scenario because I did get a ticket the other night, and I signed it with the ellipsis, and then the very next day I refused it for cause and sent it back through registered mail, and I'll see if that process works. I know I got a 10% chance of it happening, right?
Probably. Yeah, they're going to ignore it. They'll move it to a different county and rebill you again.
Okay. They'll move it to a different county.
Yeah, different jurisdiction, yeah. And then they'll come at you from another thing, and they'll declare you in default on the first one or the second one. So you got to make sure that you watch where they're going to come at you and send you and they'll do all kinds of other things. They'll sue or dump the service and everything else to get you the defaulted.
So as long as you're chasing their rabbit, they're in control. You need to create a trust or express a trust.
Yeah, right.
So just wait for a case number to come up and claim that as arrest.
Or yeah, once you get the case number, yeah.
Couldn't you
If
do
you
that
refuse for cause and give it back to them in 48 or before 72 hours, and they still come at you, aren't they in dishonor?
Yeah, but that's debtor creditor. Where's that in trust?
Which I understand that completely. I just figured I'd throw it out there just to see what would stick to the wall on the debtor creditor, and I realized that the whole time, but I figure it's a great opportunity to try it. And
shouldn't it work anyhow?
Maybe 10% of the time.
at their discretion?
What if you're what if you're purchasing either a new or used car, and you don't want to basically sign the title over to the state? How can you go about doing that? Well, I think they transferred the MSO title from the beginning of, especially if it's a used car. They've already got the title. All right. How about a new car? Okay, if you check that little block when you purchase it on there, you give them power of attorney to transfer it. So you make sure you don't check that little the tax title TT&L block. Tax title and licensing. That gives them power of attorney to transfer it over.
Would they discontinue the sale at that point?
So they probably will. Now you got to come at them for a breach of contract, which is really a breach of trust.
And that
Tax
contract
title and what?
The TTL, tax title and license.
So in that case, the contract would be the offer that they got you to sign initially.
Mm-hmm.
You
didn't express it as a trust, did you?
No.
Probably not. Yeah.
Well, you can if you use an ellipsis, right?
Yeah, from that point on. Yeah, that's yeah. And if you're really good, you don't have to. You can defend it because it was your intent and purpose, really.
But the ellipsis is one little indication that qualifies your signature, correct?
Yeah, that gives you that there's missing stuff in there, and then you can put additional words, and it's by grantor that's missing in there.
Opportunity later to come back and put it in.
Uh-huh. But back to the court ticket thing. You wouldn't have to have a case because you got a case number on the ticket itself. You could, right as soon as you got the ticket, you got the numbers. You can start address right there.
That's what I was thinking. You just turn the ticket into the trust res, a copy of it.
Yeah, that's right. You got the numbers on it. That's the title. That's the debt title.
Okay. Well, what if they just what if they actually accept my refusal and it just goes away? Can I still turn it into a trust and bill them for it?
Why not?
I don't know. You could try. It might be double dipping, but I don't know.
Probably wouldn't matter if they didn't process it. There's no bonds behind it.
And that's the idea behind doing it.
And it didn't, then you'd already be ahead of the game because you already got your process started under a trust.
Right.
This is very interesting. People are starting to think trust. But public policy is private law, and they're using their private law and only for attorneys, and we don't have to use it. And if we want to really go in the private sector and get out of the state and go back to the county, we should have the right to do that.
We do have the right to do it. It's a matter of qualifying our signature and expressing.
Mm-hmm. Christian, I have a question for you. Mm-hmm. Go ahead. I sent in a title. I got my dad's car when he passed away, and it was signed over to me by my mother on the title, and I accepted the title and for value, and I sent in
on the information, and I had to register for a new title. I sent that in, and I accepted that for value. No, I didn't know anything about the trust at that time. So I accepted it for value and sent it in, and accepted the fee for value and returned it for I'm getting an echo. And I wanted it, and I returned it under settlement. And they never did send me the license plate or the title back. And I made a copy of everything. So what would I do to turn that into a trust and get the state to do what they have to do?
3 steps: claim and prove title, merge that title, and then collect on the disbursement.
Okay, so I would do that by writing a letter.
No, you got to take and get the 4 necessary elements: the intent, purpose, and the parties, and then the specific trust res, and then create a record of the transfer, one of the methods of formation.
Okay, that's the part that I really don't understand how to do that.
Okay, first you got to claim the property to be used on a 1.
Okay.
And once you claim it as yours, then you can do the 3 transfer.
Okay, I see. Okay.
Prior to the actual UCC3, you would have sent them by, say, notary presentment with the green card, sending it certified mail, and whatever the trust res was, the titles and stuff, you would have sent it to them.
Right, I got the green card back.
And then you would have had an indenture in there saying, something about, so that you had a segregated trust res, so that, you want it back.
Okay.
Then after you've done that, and that could have happened, say, 3 years ago.
Well, actually, it happened about 4 months ago.
4 months ago. So that was a present transfer 4 months ago. But now I'm getting around to making a notice of that. And that notice is going to be that UCC3. And all I'm going to do is make references to the specific number that I'm going to assign to that, which would be a registered mail number that I'm going to send to myself and cancel it on a letter. And I'm going to use that number for that documentation, and all that stuff is going to be referenced by that. And that notice, UCC3 notice, is going to have that number on it. And I'm just going to be transferring that number officially on this notice to them. And now I've got a record that I can bring into the public that they can see. So there's a public document and also a county recording of that. So I've got 2 records.
Yeah, no, it doesn't matter what
transfer 4 months ago when I actually sent them the trust res property.
Okay, it doesn't really matter which state I file it in, does it?
No, I'm just needing to create a record.
Okay, because I did this in Wisconsin, then I moved to Virginia, and that's where I am now. But there was the state of Wisconsin that's holding the title. So it's the state of Wisconsin that I'm going to be interfacing with.
Oh, okay. It doesn't really make a difference what state. But you're living in where now?
I'm living in Virginia.
But Wisconsin's got the title.
Yeah. Because I sent it to them just before I moved to Virginia, about a month before I moved to Virginia.
Well, it's like, okay, how valuable is the car? Is it worth it to you, to bring an action in Wisconsin when you're in Virginia?
Well, actually, what I wanted to do was, if the cop pulls me over for no registration, I want to be able to prove that's my car, and that it's that the state of Wisconsin is the one that's in dishonor.
But the only thing that these public entities are going to see is a colorable title or a license plate.
Yeah, I realize that.
You know, here's where you need that do not detain passport that if they run something, they can, you know, you're outside their jurisdiction. And we haven't gotten that far yet, so. And the DOT may be working that great right now either, so.
Well, I was thinking of that today, and with the Indian nations have already been identified in the lowercase United States as being a foreign country. Since it's already in the UN, we can go in under the radar on that one. We just have to find the document that states that and refer to that document to get our embassy passports.
That's not what you want to do. You want to go on the county, small C county.
So how do you do that?
Go on the greatregistrypost.org or meet other people of your own mind in your own county. Become a man on the land in their districts of 10. Each county is divided into judicial districts. You just do a Bible record and do a publication of your family. And you might have to change your address to a private, non-military industrial complex address. For example, you would be like, you know, the Smith House, General Post, Rural Route 4, Placer County at large, California Republic.
Or you could be, you could still have your apartment building number and then segregate the zip code, couldn't you?
No, you wouldn't have your apartment number. That's the military industrial complex number.
Oh, I guess up here.
You would be your house or your apartment on your judicial district.
Has anyone gotten a passport, an embassy passport?
Create your own Ministry of Travel on your own county.
That won't be recognized by the UN.
You don't want it to be. On what we're trying to do. Right. Why would you want them to be involved? Just like right now, the state of is run by the Queen of England. You have to provide a Social Security number to get a state of license. So you're under the jurisdiction of the Queen.
Yeah, but the problem is not leaving the country. The problem is getting back in.
That's what we're talking about.
It has to be recognized through the State Department. Because there's a lot of small countries, these micro countries that come out with passports.
The county is the de jure law. It's where you can't have a state without counties. The country is a tree of counties.
Understand that, but they're not at a port of entry in regards to getting back into the country.
You're being born again onto the land out of the military-industrial complex. You keep wanting to go back into the military-industrial complex.
How else are you going to get back in other than a port of entry?
You don't want to. You're just going to be on the county. It's simple.
And then, let's say you want to travel abroad. How are you going to get back in if you're not going to get into a
Get your own papers through your Ministry of Travel. There's an assembly of, there are people, men and women on the county. There's an assembly nationwide right now.
What's that website again?
GreatRegistryPost.org.
Thank you.
It sounds good, but have they actually used it to travel abroad?
I don't think so yet, but it'll be flying.
All right, I'll wait and see. I'll wait for the movie.
That's cool. There's a lot of good people doing it. They know what they're doing. Dan's on the call. He does seals. He makes seals for people.
Yeah, I've heard him, yeah. Before.
But look what's going into, it's like, I look at it like we're on the Titanic and somebody whispered in your ear and said, hey, this ship's going to sink, would you jump off and swim to the iceberg or swim off and try to make it back to shore? Or would you just keep riding the Titanic?
And no place to go.
Well, you could swim to shore. You could probably make it if you got land in sight, you know. Well, if you got land in sight, it's time to abandon the ship, I think.
Well, the only problem with that analogy, you're saying that the ship's going to sink, and from what I've seen, it is going to be crippled, but it's not going to sink.
The ship of state is a ghost ship. How can a ghost ship even float?
Empty.
Hey, Steve, Dan the Sailman.
Yeah.
Exactly. I'll give you one example. A guy was coming back in the country from Mexico, and they stopped the guy in front of me. He said, "Are you a U.S. citizen?" He said, "Yeah." So stand over here. We're going to examine you. So my friend went up to there and he asked, "Are you a U.S. citizen?" "No, I'm not." "Well, where are you going?" "I'm going home to Modesto County." "Oh, we'll pass right on through then."
Right.
No jurisdiction.
Mm-hmm.
Unless you give it to them.
Yeah, we all went to the public fool system. We all, ran down that rabbit trail and ended up in this rabbit hole. And now, like I say, it's time to swim to shore and know who you are and be a man, quit being a fiction, and quit getting permission from the Queen. We're entitled to equal weights and measures. The whole 20th century was a century of horror. It was just war after war and depression after depression. We're still experiencing it. Until we get rid of that whole system, we're screwed. We don't have a future with the Federal Reserve Bank system. Their system is to depopulate with either forced vaccinations or chemtrails, and we get in a Tupperware FEMA coffin that they got piled up in all the train yards.
Can we get back to trust, please?
Well, we're just talking about the choices that we have to make right now. Yeah, we can get back to trust.
Okay, anybody else got a question for trust? Mm-hmm. Any other questions?
Yeah, what's the workshop?
Yeah, go ahead.
Was that you, Carlos? Go ahead, Carlos. Yes, thank you. What is the workshop, Christian?
The specific date?
No, I'm not pushing you. I just want to gather my plans. I need to travel down.
Yeah, I've got the next thing I'm working on here is the registration application. When I get that done, that's when I'll be announcing the thing.
Okay, I mean, on my behalf, I have no rush at all. I just want to do it right and learn it right. I just want to make some plans so I would let.
Yeah, I'm really not in any rush either. I'm, kind of building up a head of steam, and that head of steam being, say, knowledge, other people with knowledge.
Right.
And because I know if we started this thing 3 months ago, there have been a lot of questions that nobody knew and understood anything about. But now that we waited, people have a better understanding, and we can go into the workshop with a higher degree of knowledge.
I understand.
And that way we don't have to spend so much time on this basic stuff, because everybody's had more chance to learn it. Otherwise, I'd have to go out there and explain, the moving titles process and the concept, and we won't be getting to trust because I got to teach everybody how to move a title.
Right. All right. Eric, go ahead, please.
Hey, are you going to give us at least a couple weeks lead time once you announce it?
Yeah, right, yeah.
Good. Because, for example, for Carlos or anybody else, if we're out of town or whatever, we want to make sure that we can be in a position where we can attend. One of the things that I looked at recently was 7-104, negotiable and non-negotiable document title, just because negotiable is public and non-negotiable is private. And I wanted to read it for the group and maybe have some discussion about it, just because if people have a clear understanding of the difference between public and private pursuant to what it says under 7-104, might help everybody get a better working knowledge. So, may I?
Yeah, go ahead.
104.
Of what? What does that refer to? 7-104 of what?
Of the UCC.
Oh, okay.
It says, A document of title is negotiable if by its terms the goods are to be delivered to bearer or to the order of a named person. And then it says B, a document of title other than one described in subsection A is non-negotiable. A bill of lading states that the goods are consigned to a named person is not made negotiable by a provision that the goods are to be delivered only against an order in a record signed by the same or another named person. And then it says, C, a document of title is non-negotiable if at the time it was issued the document had a conspicuous legend, however expressed, that it is non-negotiable. So, for example, the conspicuous legend, could that be the ellipsis?
Yes, that could be something that's going to be conspicuous. In fact, that gets used same wording that they use under 3-115.
Are you going back to 3-115 to get an idea of?
Yes.
Okay, I'll go there with you.
Can you, in the meantime, spell censure, please? S-E-N-T-E-U-R? S-E-N?
S-E-I.
S-E-I.
N-T-E-U-R, I believe is what it was. I know I had the same problem. I'm trying to remember how it was spelled now. Let me see if I can put that in my file.
Yeah, 3-115 says really the contents of which show at the time of signing that it is incomplete. That the signer intended it to be completed by the addition of words or numbers. So I think the ellipsis of 3 dots is, enough content there to show that it was your intent. I mean, you're the only one who can verify your intent anyway. What did you intend it to be?
Great. S-C-I-E-N-T-E-R.
S-C-I or S?
S-C-I-E-N-T-E-R.
S-C-I-E-N-T-E-R.
Thank you.
S-C-I-E-N-T-E-R. Okay.
Yeah.
So going back to 7-104 and the things that I read, really to qualify our signature by using a conspicuous legend such as an ellipsis and thereby rendering it an incomplete instrument, that is a clear way to make it non-negotiable.
Yeah, and you could put non-negotiable on it as long as you didn't try to negotiate it then.
Okay.
And I like what it said there in B, it's in the last sentence. It said, by a provision that the goods are to be delivered only against an order in a record signed by the same or another named party. Well, the order, that's non-precatory language. That's an order, a command, a direct, or so if you have an order, there it is.
Right there, non-negotiable and non-precatory in the same paragraph.
Yes, right. Mm-hmm.
Now, some of that wording's a little bit confusing when you read that. It says a bill of lading that states that the goods are consigned to be a named person is not made negotiable. So you could say it's non-negotiable by a provision that the goods are to be delivered only against an order. It's confusing. I don't really get that.
Mm-hmm. What's official comments say?
Oh, okay. Let me go to 7104. because this article deals with a class of commercial paper representing commodities in storage or transportation. This commodity paper is to be distinguished from what might be called money paper dealt with in the article of this Act on commercial paper, Article 3, and investment paper dealt with in the article of this Act on investment securities, Article 8. Class of commodity paper is designated document of title following the terminology of the Uniform Sales Act, Section 76, Section 1-201. The distinctions between negotiable and non-negotiable documents in this section makes the most important subclassification employed in the article, in that the holder of negotiable documents may acquire more rights than its transfer or had. The former Section 7-104, which provides that a document of title was negotiable if it runs to a named person or assigns if such designation was recognized in overseas trade, has been deleted as not necessary in light of current commercial practice. The document of title is negotiable only if it satisfies this section, deliverable on proper endorsement and surrender of this receipt. Will not render a document negotiable. Bailees often include such provisions as a means of ensuring return of non-negotiable receipts for record purposes. Such language may be regarded as insistence by the bailee upon a particular kind of receipt in connection with delivery of the goods. So let's go back in a minute and talk about particular kind of receipt, because there might be some.
I was just going to say.
Okay, go ahead. We'll talk about it now and keep going, because
What are you thinking there?
Well, I'm trying to figure out what that particular kind of receipt is. Is that special deposit?
Yeah.
Okay. So, for example, promissory note, traffic ticket, whatever we make the res is our special deposit, that particular kind of receipt.
A, also known as trust receipt.
Okay. And if there's anything else that I just read that you keyed in on.
Well, I had underlined makes the most important subclassifications and may acquire more rights than the transfer had, so they're not for that. The document of title, I always think of a document of title, birth certificate, for example.
So going back to the foreign situs.
Mm-hmm.
Going back to the state secret, all the things that they don't want out in the public.
Yeah, it's like we're looking at it through a mirror. If we see through the mirror here, we are on the other side, and we see for how it really is. It's just this UCC is hiding on the other side, so that you can't see through it. You get caught up in it.
Actually, with some of the stuff in the UCC, it's kind of like it gives you the opportunity to kind of look through the fog and see something beyond, but you're not quite sure what's there.
Mm-hmm. Well, it's like Article 4 and 4A. 4A talks about beneficiaries. Here all along we talk about funds transfer, thinking it was UCC. Now it's talking about beneficiaries, which is trust. We're making trust transfers, not funds transfers. Documents of title being any kind of title that you want, trust res property.
And the moment it becomes res is the moment you sign it, correct? The moment you give it energy. The moment you give it energy, right?
Yes and no. It could be, the moment I signed it was just a manifestation of my intent of it being trust res property. Really was the intent, which comes back down to what he's talking about, sent here.
Which comes right down to declaration.
Yes.
To our master law form, which would be the DOI.
Yeah. Now we're getting down to the real nuts and bolts of the whole thing. It's holding everything together. Which was his intent
you really don't need an ellipsis. If you can prove your intent, and the only way I'm going to disprove my intent is if I listen to them, because they're going to get me to disprove my intent. But there's nobody can get me to change my intent unless I want to. And down to knowing and understanding that this is all trust.
And knowing and understanding is sent here, but without that, they'll view us as not having competency and capacity, right?
And now I'm not a fiction because I got sent here, which is
right.
Knowledge and understanding. This is all a trust. I'm not incompetent any longer. I know. I understand. I comprehend. Now you can't be debt or creditor.
And that goes right back to the little softballs that the judges try to throw to us in the outlaw side of the court.
Mm-hmm.
So when you go in there pro se, they're really looking for you to really express trust. That's what they're really looking for at the heart of it, aren't they?
They're wanting you to be the trustee, and you're the only one who can make the payment. But you never declared it to be a trust, so how can you be the trustee? You must be a debtor creditor. If you're you got to make payment with Federal Reserve notes. Otherwise, you would come in as trustee, express the trust, and pay with your private credit.
Are they really wanting you to be trustee, or are they just looking for you to really be sent here if you're coming in there as pro se?
Well, if you're coming in as trustee, I guess obviously you know and understand, and then you are sent here. You're not the fiction. Can't be construed in their realm. Now you got the substantive rights of the real man. Now you're the man on the land.
So, Christian, shouldn't we be called sentient sentiers?
I guess so. You might want to put that disclaimer on there.
Yeah, I was thinking of saying that. I mean, you're a sentient man, but you're a sentient sentier, because then you're deliberately and knowingly.
Well, sentient man means that you don't understand what's going on. I think that's what you asked. Do you realize what we're doing here? You know? Do you really know and understand how we're operating in this court? Because it's not debtor creditor, it's trust. The public side is a dog and pony show, hiding the fact that you got equity and a trust in Chambers. Now, if you were really a trustee, you'd know that. If you were a real man on the land, you would know that. But since you don't, you got to be a fiction because you're acting like one. And your actions override what you say. Your words. Your actions are your manifestation of your intent. And then you create records of your intent, even though you didn't know or understand it under debtor creditor. I'll go back and correct the whole mess by expressing it as being a trust and act like it's trust.
And you said the credit's sitting there.
Yeah, it's all locked up in trust waiting for you.
Waiting for us to correct our IMF.
Mm-hmm.
And they got to create the legal fiction to protect it too, because otherwise it would just be squandered everywhere, wouldn't it?
Probably, yeah. Or else the creditors would take it.
So going back to 7-104 under negotiable and non-negotiable, the reason that a fiction is negotiable is because they're not expressing that they're censure, and you're basically throwing yourself at their feet, going, "I don't have capacity. I'm not competent. Do with me what you will."
Right, and you're volunteering for it.
Okay.
You're falling into the dishonor. You're incompetent, and you go to jail as a trustee.
That they construe to be debtor creditor.
Yeah, actually, you construed it to be debtor creditor. They knew it wasn't debtor creditor.
You volunteered for debtor creditor.
You volunteered for debtor creditor.
That goes right back to Winston Shroud said, is nobody has ever gone to jail who didn't volunteer for it.
Yes, right.
Okay. And of course, non-negotiable is because you express your substantive rights and the right
arena place, in Tamra, and you take your right title, you claim your right title and interest, so they no longer have claim upon it.
Right.
Okay. That's really the best definition and understanding we could possibly have of the two sides of the black and the white, right?
Mm-hmm. Comes back to that definition under state secrets.
But when you do that, you're still your res is still their property, and you're just using your credits to renew the same lease or the same annual ownership right or privilege.
Well, it can't be a lease because a lease involves money and payment, and you can't have a lease. Really, it comes back. A lease is another relationship.
Yeah. There's no money in payment, right?
And besides, once you claim and you take it away from them, you're not renewing your right with them. You're claiming your right.
Mm-hmm. I'm not making a payment with money, their money. I'm making a payment with trust res, which is a thing.
Which is your...
And the best thing to do is really like to get it out of there and do your own chattel deed and take care of it from then on. Get it out of commerce.
You could, or also you could terminate it and form another trust and have them put the trust res property in your trust.
Could we liken our signature, which is our res, to, for example, under debtor creditor, how we claim our sweat equity when we buy a house and we repair it? Could we liken those two together?
The signature is the most valuable piece of chattel that you own, whether it's real estate or personal, because it represents it all.
And so does our signature represents our labor.
Yes, and it represents your intent and purpose.
So it even goes beyond labor. Okay.
Mm-hmm. Yeah, it represents your knowledge and your understanding.
Right. Your signature created the trust.
It is your seal. I don't need an except for value seal. My signature is my seal. It represents my understanding and my censure. My intent, my purpose. It is who I am. It's a manifestation of who I am, whatever I want it to be.
And without our manifestation, not one drop of oil will come out of the ground, not one speck of gold. None of it.
Right. We're the whole key.
The IRS knows better on the signature. I had an IRS, they were trying to collect the money. I assigned it, did not do anything else, sent it back, never heard from them. So they know what the signature means. Are you there?
Yes, Chris. I heard that.
Yeah, okay. Have you ever heard of Puerto Rico Trust? Puerto Rico Trust?
Yeah, Trust 62.
Yeah. Are they worth talking about? Obviously it's debtor creditor, right?
Could be that they are holding some kind of assets that's pertaining to some kind of trust, obviously.
I mean, do they have any function for us? That's my question. Any value?
I don't know if it's a particular importance to us,
Okay, good. If it has no value to us, I'm not interested in finding out.
But it does bring up an interesting subject for conversation. If it's a trust, what is their res?
Yeah, that's why I brought it.
Mm-hmm. But I really don't care where the trust res is stored. If they're the trustees of it, they're taking good care of it. Now I want it back. I want to put it in another trust that I designate and I'm solely running.
No, but what I'm getting at is what is the res of Trust 62 specifically?
Well, it could be, the assets of we the people. Who knows? Could also be bonds drawn up against those assets.
The bonds, the obligations. It could be the IRS regulations.
Possibly. Yeah.
Okay. That 9,400-page manual or whatever it is, right?
Your stolen birth certificates, and your stolen Social Security accounts.
63 million statutes and codes, yeah.
Did you say 63 million?
Yeah, 63 million statutes and codes.
And they're working on passing more all the time.
The obligations of the debt of the fiction United States, which is free. The offer for the debt is free. The offer for the obligation is free.
Of course, yeah, it sure is. Real free. Boy, if that isn't a good reason to express trust and claim and prove, I don't know what is. 63 million statutes and codes.
Yeah, the bonds of obligations. It's all about debtor-creditor money, commerce. In the public realm, commerce is king. Commerce is sovereign. Unless you express trust.
You know, that's the biggest aha moment I think I had in this, the fact that there's 63 million statutes and codes. Now when I talk to somebody who's still, you know, going along with the regular debtor-creditor thing, they really have no idea what they're up against.
A few years ago, I read some interesting use of trust. If you remember some years ago that Sony bought the Empire State Building.
Right. All they did was
the Empire. Exactly. And there was hundreds and hundreds of liens against those buildings.
No assets, only the trusteeship. They swapped trusteeships.
Go ahead and explain that.
No assets were transferred. Nothing transferred asset-wise. They just
put money in the trust. The building was already in the trust, and they swapped trustees.
Yeah, that's all they did. It's a good example.
And now they're making money on it.
I guess they never really stopped making money on it. They just, you know.
So there's no transfer, no transfer fees, no taxes, nothing changed.
Yeah, nothing really changed except the trustees. Yeah.
That's clever.
But coming back to that 7-104, under that particular kind of receipt, and that being a trust receipt. Trust receipt definition, Black's Law 8, a pre-UCC security device now governed by Article 9 of the Code, consisting of a receipt stating that the wholesaler buyer has possession of the goods for the benefit of the financier. And today there must usually be a security agreement coupled with a filed financing statement. Your security agreement, your indentures, filed with a financing statement at UCC 1, and that is your trust receipt. And everybody knows the definition of receipt, right? It's a record of a payment. So everybody thought UCC was a debtor-creditor thing, but it's one of those portal words. Could be a trust receipt or a record of a payment.
Now, Christian, I keyed in on something on that definition. You said pre-UCC.
Mm-hmm.
When did the UCC come about?
It's now governed by Article 9 of the Code.
But when did the UCC come about? Because something I keyed in on that was pre-UCC.
A law merchant was the forerunner of UCC, and when was that, like in 68, when UCC came out?
Okay.
Back coincidental when they basically got rid of the silver backing of the Federal Reserve notes. When we went totally into a debt system.
So they had to have a manual for debtor-creditor, basically.
Which was UCC, forerunner being law merchant or Lex Mercator, which is nothing more than Jewish Shtar, back all the way traceable back to Babylon.
unconscionable contract, mortgage debt pledge.
And if we wanted to file colorable action in the federal court, you taught me how to comport the UCC to the Florida statutes, but how do we just cite the UCC directly in a federal lawsuit, or does it comport to U.S. code?
Well, you could use UCC direct in federal. Just like use 7-105.
Okay.
That would be in federal. You wouldn't have to put like 677.5.
Okay. But I didn't take for the trust path you were going on. It's just something I keyed in on because I was up when
Unmuted.
You see.
Muted.
But back to trust receipt. I'm sorry.
Well, I'm just stating, I'm reading UCC more like with trust eyes, and I see different things in there that I didn't see before. Because I had debtor creditor eyes. And I'm starting to see more trust in UCC than I saw before.
The fog is clearing more and more, huh?
Yeah. Mm-hmm.
Now, for the man that was talking about with the county registry, does that seem like the right thing, so we can find ways to more ways to not be effectively connected with a U.S. trade or business?
Well, I think your government of the man on the land is really it was formed in the county. It's from the county up. That's where it really starts. That's where its roots are. But we've so far left that behind that even the county today is not the county of the original. But first, what's holding all that back is really trust, because everything is held in trust. And first, you got to terminate that trust to get it back.
Terminate that trust. When you say that, what do you mean exactly?
Main trust is being America, the Republic, common law, real money is all locked up in trust. You got to terminate that trust to get it back.
Are you talking about the SEDIC Social Security Trust, you mean?
No, I'm talking about the Republic, America.
Oh, okay. Now, speaking of the SEDIC that we have talked about on many occasions, is it really any sense in terminating that, or would we actually want to keep that on the colorable public side so we have an interface?
I need some kind of an interface, but I think in order to clear the debt, I think we have to terminate that trust in order to pay the debt.
And you're talking about the war debt?
Yeah, war debt, where all debt, any debt. All this debtor creditor stuff that we've been is creating nothing more than debt. All these indemnity bonds, offset bonds, and all that stuff, in that public realm is creating more debt. We got to get rid of all that. Got to get rid of it by merging the titles. That makes the payment, that terminates the trust, and now that republic, that ability, at least for that individual person, that man, that real man or woman, then it becomes available for them.
So when you speak of paying that debt, you're talking about terminating it and taking the, I don't know if I want to use the word debt, or funds, or whatever's in that trust. The residents in that trust would probably be the proper term. Using that when it's dispersed to pay that debt, is that what you're getting at?
Yeah, that chattel, whether it be real or personal.
And would there be a limit to how much is to be paid, and then the rest would be distributed to the person who's merging the titles?
Yeah, there has to be a set amount that's still owed, especially on the principal. Well, corresponding amount equal to that to zero it out.
So whether we're terminating that trust or a court case trust, or a case that we turn into a trust, or a
mortgage, any of those that we actually merge the titles of and terminate, there's going to be a dispersion. But in any of those, they're not going to want to actually distribute the revs to us. They're just going to want to put that in some type of entity that will hold that we can actually receive interest off of. Is that really the model that we're looking at in any of those cases?
Well, I would say that there's, on the private side, that the trust I'm going to terminate and then form another trust that then I'm going to be forming per my instructions. That all that, with the residual, the remainder from paying the debt is going to be dumped into. And then I need another entity on the public side to interface into commerce with. That its source is going to be from that, non-resident alien, and the interest is generated on the public side. Its source is going to be foreign, which is the private,
which is our energy.
Yeah, it's not effectively connected with a business or trading in the United States. It's not taxable. It's outside, foreign. It's non-resident alien. It's the whole ball of wax outside.
And the res is our energy, correct?
Yeah, it represents our energy, our future labor.
Okay. So it would be the same for both a court case and that SETA case on security trust, for example. It would really be the same. That scenario.
This case is nothing more than just a trust that's set up to operate under the statutes and codes, which is nothing more than debtor-creditor again, so that fiat currency could be generated for more debt that they're using to operate as money. You got to treat this trust res and go into the private side and declare it as being your trust res. That makes the payment against it as a special deposit, a trust receipt. And you merge the titles.
That makes the payment the trust receipt.
The merging of the titles makes the payment.
So that same document, that UCC3, which merges, is the declaration, because you're going to show that you're going to transfer with it, correct?
It's the notice of a trust receipt.
Okay, but it's actually going to serve multiple purposes. It's going to do transfer, it's going to merge, and it's going to serve as the receipt, correct?
It's going to be the notice of a transfer. Yeah.
The notice of a transfer.
It's just the notice of a transfer. But it's a public notice that they can see is recognized as being... The actual transfer was a private transfer, but the notice was a public notice. Then they can see the public notice. Public notice.
And we could do that transfer by old declaration in camera.
Well, now if you're talking declaration, now you're grantor and trustee within your self-transfer and trust property, and the only way to do that is by declaration. But if you're going by a third party, you're giving the trust res to a third party, you can't do it by declaration. You got to do it by transfer.
You could do it by oral transfer in camera.
Do it by oral transfer? Is that what you said?
That's my question, yeah.
I would need a record of a transfer, and there's where we'd have to have, the green cards, the proof that I mailed it, and the documents went to them, and that was the trust res.
And the reason you want the records is if for some reason they fail to disperse, they're in breach.
Right, I got the means to prove the trust.
And then if they do breach, then you have a colorable action against them.
Yes, on the public side.
Okay. That really helps a lot. Now, if they did breach and you have that colorable action against them, you would simply file your suit, and again, you would do a protective order and go in camera because you wouldn't want to reveal your CCI, right?
Correct.
All right, just try to make sure we wouldn't reveal that information in the public.
No, if I did, I would waive it. I'd give it right back to them again.
And then you'd be under the bonds of the statutes and codes.
Yeah. Mm-hmm.
be under that obligation.
And I would be incompetent again because I commingled trust res. I crossed it from private to public, or public to private. It's something I can't do. That proves that I'm incompetent if I do that. And I'm right under the statutes and codes because I'm incompetent. I'm not sent here then. I don't know and understand.
So don't get all fired up thinking, okay, they breached, I'm going to sue them, but then go ahead and let the other side compel you for discovery, and go ahead and let that get into the culpable side.
Yeah, I'm going to put a protective order on it, which sets up CCI information, trade secret information, protected state secrets, which is privileged. And privilege is really under the discovery. That's where a protective order is, because it's privileged information.
Christian?
Yeah.
Question. You keep talking about protective order. How do you come up with a protective order? Do you write it in a letter form, or how do you do that?
Well, under your local state rules, you're going to go to your discovery section, and where it'll talk about protective orders under discovery.
Okay.
And usually in the state, there's got to be a state book of standard forms, what's called, was it Benders? I forget now.
Benders is one of them.
Benders, and then in the federal also, there's O'Connor's has forms, and I've got the O'Connor's forms. I think I gave it to you, Eric, didn't I?
You did. Christian, can I jump in here on this?
Yeah.
Yeah, for everybody on the call, I've gathered a lot of information about protective orders, and I think I have enough to write a really, really good one. If anybody wants to join together as a group, we'll work together as a group to put one together. And then, Christian, if we could all run it by you to see how you feel about it, if we're going to be able to get the order.
It's really how, say, O'Connor's defines what are the necessary elements, because if there's, say, 4 necessary elements to a protective order, you must have all 4 necessary elements, or else you don't have a protective order. And it won't be granted. So it's really, like O'Connor's will give you the necessary things or the necessary elements that you need, and probably under your local state rules, it'll give you the necessary for the cause of action for a protective order.
And it doesn't have to be 100 pages long, right?
No, there's one example I gave for Eric. It was only like 2 pages.
Yeah, very short, maybe 3 at the most. But no,
actual protective motion.
That brings up another question. So, do we first put in a motion and then a protective order, or do we just put the order in?
No, you put them both in at the same time, because then the motion tells the court what you want and what's necessary there, and then the order, the judge signs granting the order.
Got it. And we would submit them to the JA, correct?
You put that through the clerk of the court.
Oh, okay.
That motion is a public motion, and so is the order.
Okay, I got you. All right, and if anybody on the call wants to get together with me and work on the protective order, you can find me at Skype at Imagine the One.
Skype, Imagine One?
Imagine the One, numerical number 1.
Okay, keep talking for a little bit. I got to take a little break here. Be right back in a minute or so.
Okay.
What do you mean, Imagine the One? Just Skype number 1?
No, Imagine the One is my Skype username.
Oh, Imagine the One. Okay.
Correct.
And if we can to do that. Okay, Imagine the One.
No, but if we could get 5 or 6 of us together, we can agree to a conference call. We can go through the material, and we can put together a real good one in just a few days. Carlos and I have been talking about it. I know Carlos is on board. If anybody else on the call would like to jump on, please speak up now.
Yeah, that's a great idea, Eric, because we can get it done easier and quicker. Because, we know everybody's busy, right? But we need to dedicate some time to this also.
So I'll participate on the call, but I'm not on Skype.
Well, you could get on Skype for free if you'll sign up for a username. If you don't mind.
I had Skype and got rid of it. because Skype integrates through your whole computer system, and their agreement lets them wander through your computer whenever they feel like it. However, you email to start with, and you get onto a conference call. I have Connor's federal manual. I think it's in digital form.
Right. Wow, that's great. I'd love it if you want to share that with us. But I do have the motions and the protective order from O'Connor's, and also I have several that were written for different cases that I got off the internet, and I have a bunch of information that we can all share. It's for the gentleman.
Email then.
For the gentleman that just spoke before you did, and I'll get your information in a second. But were you the guy that was talking about the county registry?
Correct. I'm Steve in California.
Hey, Steve. I'm Eric in Florida. Steve, what's your email?
S-Sawyer, S-A-W-Y-E-R, like Tom, at sbcglobal.net.
Because, Steve, I'm really interested in getting involved with my local people for the county registry and get some like-minded people that way.
If you're in Florida, there's some people down there.
Yep. Okay. And
so what's your email, Eric?
ruleoftrust@gmail.
ruleoftrust@gmail.
And for the gentleman that was speaking just after Steve,
Daniel.
Was that to you, Daniel?
Yeah, I'm Dan, the Seal Man.
Hey, Dan. Hey, if you want to send me...
okay. I volunteer to drop everybody's sovereign seals for them. I've done hundreds of them.
Okay,
so
great.
If you want a great seal, then I'll be glad to help anybody.
Wonderful.
I'm at Trust Core. One word, TRUSTCORE
All right.
And you're at Rule of Trust. Trust single or trust plural?
Single.
Okay. That's right, where?
At Gmail.
Okay.
Cool. And there's a few other people that I'm going to try to get on board that are pretty darn talented at this too, and that's Chris Summers and a woman by the name of Phyllis that's a close friend of Chris's. And I'm sure that if we can get everybody, including Carlos and myself and you guys, onto a call, we'll have a wonderful conversation because they're all pretty good hunters when it comes to research.
Yeah, we met with them last week.
Oh, then you know.
Yeah, I know. Phyllis is a real deal. She's hot.
Yes, she is. I don't have to tell you, Daniel.
Yeah, I went in. Yeah, she's terrific.
When's the best time to get a hold of you, Eric?
Pardon?
When's the best time to get a hold of you? If I wanted to talk to you.
Who's speaking?
Floyd.
Hey, Floyd. Well, just send me an IM or just call me on Skype if I'm in front of the computer. We can talk.
Okay.
Usually afternoons and evenings. I'm often on tonight's call. As a matter of fact, I try to always make Tuesday nights calls because we get a much better opportunity for conversation as opposed to Christian getting on Wednesday and he reads for a while, which is good information. But I get a lot more out of our conversations on Tuesday.
Yeah. Okay.
Where's Carlos at?
California.
Oh, how you doing, Carlos? Where are you, northern or southern?
I'm in Los Angeles.
Oh, okay.
Where you at?
I'm in by Sacramento.
All right. Well, let's keep in touch.
Lincoln.
Keep in touch.
Yeah.
Floyd, would you like to participate in us putting together the protective order?
Yeah, I wouldn't mind doing that at all.
Okay.
Now, is that just something that you do, like if you're transferring something, the protective order, it protects everything while you're transferring?
No, what the protective order is, it lets the court know that you have CCI, and CCI is confidential commercial information. And what that does is, if you put a protective order in a motion and a protective order simultaneously, the judge knows that there's information that they can't let out in the public court, that can't be into the public record, and it's our rights as a substantive man can't be put out there.
Trade secrets.
That's correct. The fact that we really are the national treasure is probably the best way to say it, and because
I like that.
because they can't let that out. We have to go in camera in order to express our rights as a substantive man, and what that also means that a lot of people have been putting to work or trying to put them to work for themselves is a private administrative process. Well, you can't bring private administrative process in the colorable side of the court. They can't see it. You're a fiction. They can't recognize anything you do there. So you have to get in the camera in order to show the fact that you have a dishonor with them, and then start moving in that direction as something that you can act against them from. So that's another thing you can utilize in camera if need be. And maybe when Christian comes back on, we can ask him how we can utilize that. Is there any advantage to doing that in camera, opposed to just merging titles or ordering a payment by the trustee, for example? So, and if anybody has any comment on what we can do with that private administrative process, is familiar with all this, before Christian comes on, please speak up.
Well, I don't really know that much about it, other than I've tried learning it a long time ago. But I would like to try it in regard to my getting the title back to my car, or whatever I'm going to do with it. It's just an old car, but it'd be good practice. Well, it's 95 Oldsmobile.
So doing a sweat equity deed would probably help a lot, and also a chattel deed.
Well, I don't know how.
A sweat equity claim with a chattel deed.
Oh, okay. In other words, just whatever time I put into it is what you're saying.
Yeah, you put tires and water pumps and radiators and new windshields and whatever else, plus you maintained it and washed it and changed oil, plus you paid for it. That's all sweat equity. And it's in your possession, so you do a chattel deed that it's movable property that's your personal property.
Well, it's a legacy from my dad too.
And the state has stolen the real title that you want to have returned back to you.
Exactly. So if you want to delineate that in ounces of silver specie, as opposed to you don't put a Federal Reserve note value on it.
Yeah, in silver specie. And then also, you could go to DMV and say, I want to turn my certificate of title in for the title, and if they act like they don't know what you're talking about, you report it that your title's stolen, and you create your own title.
Well, see, I have a copy of everything I've done. I have a copy of the title that I sent in for them to send it back to me, my name, and my mother's signatures on it. I've got the copy of the front and the back of the title, so I can prove everything that I sent in to them. Do you have the bill of sale? Pardon? Do you have the bill of sale? Well, actually, on the title, it showed that she turned it over to me. Well, do you have the bill of sale, though? Because the bill of sale is the real title. Oh, well, no, I don't have a bill of sale, but I can get it from her. Yeah, the bill of sale is the real title.
Is that because that's transfer?
Yeah, that's when the purchase, that took place, and
that's the one the dealer gave to the state instead of to you.
Yeah. Well, my mother's the one thing. Well, Christian, how would I work that? Because my mother is the one that signed the title over to me. So would I go back and get her to give me a bill of sale for $1 or something like that? Well, you got a power of attorney that you gave the state, or the dealer, let's put it that way. The dealer has the power of attorney. Well, he bought, my dad bought the car from the dealer, but he gave it to me. He gifted it to you, so, but the dealer, whoever the dealer was that he bought it from, was the one he gave the power of attorney, which they transferred the MSO title and over to them. They created the certificate of title, and he took the certificate of title and then added to the bill of sale. Well, I wouldn't have gotten the bill of sale then because it didn't go through. I didn't go through the dealer. I'm saying cancel that power of attorney that he gave.
then merge those trust titles and get the thing released, get the distribution of it.
Okay, so if I put it on a UCC1 and I transfer it on a UCC3, I would be transferring it to who? To myself?
So I don't transfer it on a 3. That's the notice that a present transfer happened. When did you send them the actual trust res?
In November of last year.
Okay, so there's what you're making reference back to, because that's when the trust actually was formed.
Okay, yeah.
Now, do you have a record of that transfer?
Yes, I do.
I say green card or notary or some kind of witness or something, so that you can prove that you had made a transfer back in, when did you say it was?
November,
back in November.
Right. Yes, I do have the green card.
Okay, then you can do the UCC3 transfer, which gives notice that there was a transfer back in November.
Okay. And the fact that they're holding it, well, I don't know what that just shows that they're in dishonor. That's as far as I know.
Well, they're not really in dishonor yet. You formed the trust, your dad formed the trust, man.
Yeah, he formed the trust when he gave me the car.
Mm-hmm. You got possessory title. State owns the beneficial. They're the real.
Muted.
They're forcing you to get insurance and everything else, license plates.
Right.
At their interest because they're the real owners of the car.
Okay. So now I have to transfer title to myself.
Yeah, we'll merge the title and then terminate that trust, and then you're going to probably redistribute the parties because it's been misconstrued.
Mm-hmm.
You got the same cars you have on a mortgage because the state is the beneficiary. You need to change that around if you're going to get the beneficial title, and after you terminate the trust, along with the possessory title. In other words, you perfected it. You merged the titles and perfected the title. You got a perfect title then. You're going to end up with the perfect title. You got to be the beneficiary. So you're going to have to change the parties because they're in a misconstruement. They're the beneficiaries, but you never said anything otherwise.
Yeah,
I got right. The parties.
Okay.
Hey, Christian, this is Terry. I have a question.
Yeah.
You keep mentioning that the green card is proof of a transfer. My understanding of a green card, it's only proof that something was sent to a particular person or a business. It doesn't identify what was included in the envelope, let's say. In order to do that, to have substantial proof, you need to have a notary presentment cover letter that specifically lines
so
out.
We have a David of mailing, which specifically states what was in the letter.
Right, that's what the notary presentment says, is the itemized list of what's in the letter. And that goes registered mail, and there's your proof.
Yeah.
So
then you got a green card signature that proves that they got that.
Right, so just a green card signature doesn't prove anything other than they got something from you.
You're right, yeah.
So
Well, in my case, they got the title.
Well, how can you prove that the title was in the envelope that you sent them? Unless they admit it somehow in documentation or what have you, processing.
Uh-huh. Okay.
Yeah, we have a specific document called an affidavit of service which specifically states what was sent.
Yeah, you have to line item everything that was in that envelope that was included. So that notary records that or validates that, and there's your record, along with the green card.
Okay.
That's my understanding, anyway.
No, you're correct. Right. And that affidavit of mailing would also be known as a notary certificate of service, correct?
Well, I know it as a notary presentment.
Yeah, we have it in addition to. We have a notary presentment sheet with listed, and we also have the affidavit of proof of mailing, which the notary is swearing to it by his affidavit under his hand and seal that he put such and such a document in the envelope and mailed them.
Yeah, I include all of that on the notary presentment, and they just sign one document. They put it in the envelope, seal it up, can hand it back to you to get it mailed, or they can do it for you at an additional cost, of course. That's the way I handle mine. I let them sign the notary presentment, verify that the documents are what I say they are going to be in the envelope, let them put it in the envelope, them seal it, and I have all the mail slips and green cards already attached to the envelope, and I just carry it down to the post office and pay for it.
So if I wanted to prove that I did send them the title that was signed by my mother and myself, then couldn't I make that statement and put the a copy of the green card in that package?
Well, at this point, it would be hearsay affidavit, I would think. Or an affidavit subject to the hearsay rules.
Unless you get it in chambers. Yeah.
Right. So that's...
But if we get witnesses, let's say you would be one witness and the notary would be another witness, so there you have your two witnesses.
Right, but they have to do that presentment.
All right, speaking of that, if we do get into chambers after we do a notary presentment, and what kind of advantage do we have by utilizing our private dishonor in chambers? Is there really any real advantage to it if we're going to claim it, if we're going to prove trust, and we're going to claim and prove trust, and we're going to order disbursement anyways?
For the dishonor, yeah, the dishonor is not going to do much good other than proving that you didn't get a response back or something.
So if that's the case, is there really much sense in us even going through all this trouble of the private administrative process? Really?
Yeah, I would say, because that also gives you a colorable way on a public side to come in with the collateral estoppel and use the preliminary and temporary restraining orders. Again, an equitable action.
So, for example, the process is, if in a mortgage case you do a private administrative process, you quit paying, and you're behind on the mortgage. They file this penance against you. You file an NOI and a protective order. You go into chambers. You present your private administrative process, and then the judge issues on the public side an estoppel. Is that the idea?
Right.
Okay. Now I understand. Or, for example, it issues an injunction, a permanent injunction.
Preliminary injunction. Or temporary restraining order.
Okay, which could lead to a permanent injunction.
Yeah, it could lead to one, yeah.
Okay.
That could get the whole thing thrown out, because any kind of dishonor generated by the notary is going to unclean hands.
Which would possibly compel them to try and negotiate privately with you.
Well, yeah, that's their colorful way out on the public side. Throw the case right out of court.
All right, and then when you were talking about transfer, okay, if we're transferring, for example, the res on a traffic ticket,
Muted.
how are we proving that the transfer took place? For example, they pull you over, they give you the ticket, you sign it, and later you go and you do the NOI and the protective order to get into chambers, and you do the UCC-3 to prove that there was a transfer made at the previous time. Was the transfer actually made when you signed the ticket?
It doesn't prove that there was a transfer made. It points to the actual private documents that prove.
Okay. And what private documents are we going to utilize that's going to prove?
Well,
in that case,
the documents you're going to have to come up with, how did you return it to them as a trust receipt?
So that would be the.
Did you have the, witnesses? Do you have the records?
Okay, so for example, we're going to have to give them that ticket back as a special deposit.
We're going to have the green card, the affidavit, the notary presentment, and create that. And then that UCC-1 points to that, and that county notice points to that.
Okay, so for example, I sent the original ticket back with a refusal for cause right on it. So I did give it back to them, and I did send it registered mail, and I'll get the green card back. But I didn't claim it as a special deposit when I refused it for cause.
Okay, you didn't give them any indenture to use it for a segregated trust res. Hey, I want this back.
No, I didn't. I just refused it for cause, but I do have a copy of the ticket, which I could use down the road as
a trust, though. Yeah.
But I can. So my question is, can I use the copy of the ticket down the road as res if I need to?
Well, I've already transferred it to them once. Why would I want to, the original? That was the thing that I sent them first time, so why would I do it again?
Okay.
As long as I've got some way of proving that I sent it, 2 records, then I've got the ability to prove the trust.
So the transfer did take place. So because I did the transfer, so then I go ahead and go to the Secretary of State, and then do it in the county, and then I got my 2 witnesses.
Now, where you may be defective at is that you didn't put it in that you wanted the specific trust res back, so there was no order to not commingle the funds.
So I should have done that in my cover letter.
Yeah, wasn't a specific trust instructions to set up a special deposit.
So I could send can I send a copy of it if I needed to do that in order to, with the proper instructions?
What if you send it as an addendum or something? No, yeah, I'm thinking that there might be a way around that, yeah. I don't use the 3 as assignments. And then send your indenture instruction for the special deposit along with it.
So go to the Secretary of State, create the witness there, then create it in the county, and then send the 3 in that order, or send the 3 and then do the SOS and then the county.
Incorporate the indenture with the instructions to do the special deposit, along with the mailing of the 3s to them in the county. That I would think would be the next best thing. Or, like you said, maybe take a copy, certified copy, do a tested copy on it, and do the thing over again.
So just go to a clerk and get a certified copy. Okay. That'd probably be the easiest thing, really.
The key was, you got to have trust res that's segregated. It's got to be a special deposit. I keep coming back to that Gilbert's where it talks about that. I forget what page it's on, but that or about the $500 and 20s. Yeah.
Yep.
Unless they ask for the specific $20 bills back on the 500s, then it was not a special deposit. It was debtor creditor. If you ask for 20s, the exact $20 bills back that you gave them, then it's a special deposit. It's segregated. They got to keep it segregated, and it's an in-kind deposit. It's a special deposit. It's a trust deposit. Now you got a trust. Trust res segregation is key.
So get that specific certified copy, for example. Create a cover letter with the indentures and claiming that certified copy as a special deposit and the fact that I want it back.
Right. Page 29 talks about, under section 108, talks about segregated funds. I think it's page 19, I think.
really necessary to make a special deposit if you're refusing it for fraud, for cause, or for fraud, and it has the ticket itself has no seal or anything on it? It's still res property.
He was just doing a refuse for cause, yeah. But to set it up, maybe letter for trust, then he needs to have a special deposit.
If you're exiting out of their whole system, you don't really care about that then.
Yeah, but I got to deal with the ticket. If they don't accept the refusal for cause because it's got about a 10% chance of going through, then I've got to.
But all bills are bills of exchange, and if you return it within 72 hours, they have to take it.
Well, I agree with you that they have to. We'll see what happens because they did get it back within 72 hours, but that doesn't mean that they're gonna.
Doesn't that go under Title Z at that point? Regulation Z? Yeah.
Well, it'll be great if it works, and I'll be happy to report to everyone when it does. But at this time, I'm just trying to figure out what Plan B is, or we could call it Plan T.
Okay, page 9, debtor-creditor relationship, section 42, under the example. For transfer hands transferee a bundle of $20 bills totaling $500 and indicates that she wants the money returned at a specific date. If, as is likely, the transferor does not care whether she gets back the particular group of bills, and that's the key, particular or specific trust res, or even property directly traceable to them, the arrangement cannot be a trust but is simply a debt. Thus, transferor can repay transferor any $500 and is free to dispose of the particular bills recovered. But then the inverse of that is what you want. If we did ask for the particular $20 bills back, they had to keep them segregated, and that definitely is a trust. If you don't make it so that we want my specific pen back or my specific $20 bills back, then there is no trust. Can't prove a trust.
So I have to instruct them.
Res.
I have to.
Res is one of the necessary elements. Specific trust res.
So I have to instruct them with the indenture that I'm sending the special deposit to you to hold in kind.
And I want that wording comes in that we were working on there, that on the trustee ambassador meeting, or trust ambassador meeting, excuse me, that we're coming up with the language that we really weren't using any trust terminology. I want my pen back.
Oh, because of the we were trying to talk about a more slick way to come about that.
Right.
So just the way they do, where no party needs to know.
Right.
Okay.
Christian, yes, we're asking the same type of return we're expressing the trust then. It is born by them, right?
Yeah, when you give them the $20 bills and you told them that I want those $500 back in the same $20 as I gave you.
There it is. That's expressing the trust.
Yeah, that was expressing the trust, yeah. Or I give you my pen and I want my pen back, and
same value, same one.
My pen is my pen, and how else are you going to keep my pen, but you got to segregate it, and I got to get my pen back.
Right. You're talking about mortgages, the note, the same way I gave it to you.
Yes.
Not stamped, marked, or anything.
Right. That would prove that they commingled if they stamped it or modified it in any way.
Right. And I am surprised due to the fact that they are doing so many things with a note. And if you may recall, in PC May Rest, George Mason, he told me once, he says, Carlos, if everyone would say yes one thing, there would not be any foreclosures. If they would, yes, who are you, and are you the holder in due course? Are you authorized? That's all you need to do. Because, guess what? If you go to Black's Law, holder in due course is someone who, in good faith, gave something in return.
Yeah, but here's where the construement comes in. They're construing themselves to be, and you set them up as being the holder in due course, not you, because you didn't express the trust.
I know, and I think that's in number 20 on the deed of trust. I know. Well, things we ignored back then, little by little. I'm a slow learner, don't get me wrong, but it's okay. I'll hang in there.
Yeah, we're all real due course, and they're going to say, we took free and clear of any, as a bona fide purchaser, because we didn't have a notice of any defect. You never gave them notice. And even if they had given them, if you had given them notice, they're going to say they're a holder in due course, and therefore you're cut off from making a notice.
Right.
Now, if you express it to being a trust, you could come back and say, okay, I'm holder in due course, and you could play the debtor-creditor game that way, but you didn't do that either, so.
Right, but if we go back in there and we want our rest the same way we deposited it, in the same nature that we deposited, there it is. I mean, we have to get it in the same way. We're talking about a note, not stamp or temper with.
Mm-hmm. Okay, guys, it's getting kind of late, so I'm going to call it a night.
Very good. 45.
Yeah. All right, so I'll see you all tomorrow at very much at 8 p.m. Eastern Time.
Thank you.
Thanks, Christian.
Thank you.
Okay. Everybody have a great night.
Good night.
Thanks.